at Guwahati railway station, Lordship.
Yes.
From
So
the
why will this SOP not be applicable to you then?
because Lordship, in that case, Lordship, I have to maintain the SOPs of all the states, Lordship. Because I am basically, it was booked at Tripura, Lordship. After maintaining all the formalities.
Correct, but the articles have been seized here, right?
Here,
So
Lordship.
they are lying down here.
Yes, Lordship. Lordship, your Lordship may kindly see paragraph, page 33, Lordship. After claiming that, Lordship, I have contacted with one of my Lordship, buyer Lordship, who willing to buy my Lordship, that articles, Lordship, which is unfit for industrial purpose. Lordship.
That's all right. There is an SOP framed by the state of Assam, right, Mr. Borthakur?
Yes, Father.
So according to that, you file an application. If the police endorse the same finding, then it will be done in
Lordship, I
accordance
have
with law.
already filed, Lordship. That was not considered yet.
So that is why we are sending it back. Let the police do that verification. They have not yet done the verification. Correct. This is something which you are writing. Page 33 document is your own, isn't it?
Yes.
And,
Page 33, right?
Yes, Lordship. Page
This
33.
is your own certificate. P. Ansar Ahmed and Sons. This is the petitioner.
Yes.
No, Lordship. That was, Lordship, one buyer, Lordship. That
So
process
the buyer is willing to buy.
by that unfit for human
So
consumption.
let the police do the verification. Then you submit this in front of the police.
This is the Lordship perishable goods, Lordship. So some time limit may be given.
Yes, that we will give you.
Because in such circumstances, Lordship, this Honorable Court division bench already held in custom reference case number, Lordship, that may be again, Lordship, if that is unfit for human consumption, Lordship, then different cause of action will arise. But police is not authorized.
That's right. You see, we are now, Mr. Counsel, please take your seat and hear the order that is going to be passed. This is item number
6.
Heard Mr. N.H. Barbhuya,
Yes, Lord.
learned counsel for the petitioner. Stop. Also heard Mr. P. Borthakur, learned APP for state respondent. This is an application under section 482 of the Criminal Procedure Code 1973 praying for quashing of the impugned order dated 18/12/2023 in connection with GRPS case number 221/2023 passed by the learned Judicial Magistrate First Class Kamrup Metro for Zimma of the 22,500 kgs of seized betel nuts. The case of the petitioner is that 22,000 kg of betel nut was seized by the police, and accordingly an application and JIMA application was filed. Stop. The Court of Judicial Magistrate First Class Guwahati by order dated 18/12/2023 rejected the said application aggrieved by the said order dated 18/12/2023, the instant application has been filed. Stop. Mr. P. Borthakur, learned APP, has placed before this court the SOP dated 16/9/2021 issued by the Office of the Additional Director General of Police, CID, Assam, for disposal of seized betel nuts. Stop. It appears from clause 15 of the said SOP that if the seized betel nut are unfit for human consumption, and a owner or a claimant submits a plea before the court that they would use such betel nuts as raw material for manufacture of some non-edible products, and that the same will not be used for human consumption, comma, the superintendent of police shall verify the said claim and submit report to the court. Stop. If the claim is found genuine, then the court is entitled, then the court can pass appropriate orders. Stop. In the present case, the petitioner has annexed a letter as Annexure 10 to the petition, showing that one claimant is willing to purchase the betel nut for industrial purpose only and not for human consumption. Stop. Correct?
There are two buyers, Lordship, page 32 and 33, Lord.
All right. You say two buyers. Okay. Two buyers by their letters, which are annexed as Annexure 9 and Annexure 10 to the petition, have shown their willingness to purchase the seized betel nut for use in their factory and not for human consumption. Stop. Next paragraph. In view of the above, this court is of the considered view that this writ petition can be, this criminal petition can be disposed of with the direction that the petitioner shall file an application before the court placing the aforesaid letters and the court shall, after calling for a report from the jurisdictional SP, dispose of the said application in accordance with law within a period of
2 months.
within a period of
Lordship, 1 month, because this is a
within a
pension.
period of 1 month
Yes.
after receiving the certified copy of this court's order.
They will have to submit before the in detail about the address of the those buyers before the trial.
They will file.
Yes, Lord.
So that we don't need to say. With the aforesaid observation and direction, this petition stands disposed of.
Lordship, I have to file a petition before the court. That means CGM court. Lord.
Yes, you mentioned CJM court, huh? Before the court of Chief Judicial Magistrate,
Kamrup Metro.
Kamrup Metro.
May I please, Your Lordship?
Yes, FIR.
No, Lordship, this is a charge sheet matter, and now trial is pending for the Honorable Second Judge Amin Gao. Lordship, initially the case was registered under Chapter 7, P77, 498 and 507 of I. Lordship, the FIR starts from page number 12. Lordship, in the FIR itself, Lordship, there is contradiction. Lordship,
There is.
there is contradiction. Lordship, it doesn't matches. The last four
Today
lines
is
of
the first day.
Today is the first day. FIR starts from page number 12, Lordship.
When is the next date?
Lordship.
When is the next? This is charge sheeted.
Charge sheeted matter, Lordship, and now pending for trial.
They have filed this petition for quashing of
Quashing,
the
Lordship.
criminal proceeding.
That's why I'm asking when is the next date?
On next date, Lordship.
You don't have.
In the month of May.
This is an application under section 482 of CRPC 1973 for quashing of the criminal proceeding and trial arising out of an FIR in connection with Azov PS case number 466 of 2020, registered under sections 4988, 307, 377, 511 of the IPC 1860. Stop. Issue notice returnable with next date.
22nd of April, Your Lordship.
Issue notice returnable with within 2 weeks. Stop. Mr. P. Borthakur, Leonard APP, accepts notice on behalf of respondent number 1. Extra copies to be furnished within the course of the day. Stop. Steps in respect of respondent number 2 by registered post AD within a period of 2 days. Stop. List. Yes, date after 2 weeks.
10-4, my lord.
10/4/2024. Interim shall be considered on that.
I'm deeply obliged, Your Lordship.
Yes.
Instant petition has been filed for quashing of criminal
Criminal proceedings.
proceeding, Lordship, arraignment
Sections 406, 420.
420,
Where is the FIR?
page 25, Lord. Annexures. Civiliness.
FIR is page 27.
Vernacular
Initially complaint file, my lord.
Sorry, complaint case.
complaint case, Lordship.
Loan.
Loan of 80,000, Lord. Allegation.
This is not repaid.
Repaid, Lord.
Yes, Mr. Borthakur.
My
Civil,
lord, primary basis seems to be of civil nature, my lord. Notice may be issued.
Your name,
MK Hussain.
Mr.
MK Hussain.
Heard Mr. M.K. Hussain, learned counsel for the petitioner. Stop. Also heard Mr. P. Borthakur, learned APP, Assam. This is an application under section 482 of the RPC seeking quashing of criminal proceeding in connection with CR within bracket W, case number 36 of 2023, registered under section 406/420 IPC, pending before the learned SDJM within bracket S, Lakhimpur, North Lakhimpur. Stop. The case of the prosecution is that the petitioner had taken a loan of rupees 80,000 from the informant and has not repaid the same. Stop. Issue notice returnable with 2 weeks. Mr. P. Borthakur, learned APP, accepts notice on behalf of respondent number 2. Extra copy within the course of the day. Steps by registered post in respect of respondent number 1 within a period of 2 days. Stop. Considering the nature of allegation, prima facie appearing to be civil in nature, this court is of the considered view that pending disposal of the criminal petition, further proceeding of CR within bracket W, case number 36/2023, pending before the learned SDJM within bracket S, shall remain stayed. Stop. List after 2 weeks on a date to be fixed by the registrar. Yes.
For Tambing Lodge.
Ambing. Yes. AB. Yes.
This is an anticipatory bail application, my lord.
Yes.
The FIR is at page 13, my lord. My lord, may I read, my lord?
Yes.
With due respect, I beg to state that the below named accused numbers 1 and 2 with a conspiracy had misappropriated an amount of so of the shareholders of Kalapani SS Limited during the period of 2017-18 while they were holding the post of chairman and lifting.
Yes, if they appear, then I think we can give them an interim protection. Misappropriation of 22 lakhs of the shareholders.
Yes.
But my lord, in fact,
Because if they appear, it will
yeah.
the investigation shall progress, isn't it, Mr. Bhattacharya?
Yes.
A. Hussain.
RS.
Sorry, R. Islam.
Yes.
Heard Mr. R. Islam, learned counsel for the petitioner. Stop. Also heard Mr. P. Bhattacharya, learned APP for state respondents. Stop. This is an application under section 438 of the CRPC for granting pre-arrest bail to the accused petitioner, i.e. Tohidur Rahman, who is apprehending arrest in connection of Mankachar PS case number 431/2023, registered under section 403, 406, 409, 468, 34 of IPC. Stop. The case of the prosecution is that the petitioner had misappropriated an amount of rupees 22,35,972 of the shareholders of Kalapani SS Limited during the period of 2017-18, while he, along with the co-accused, were holding the post of chairman and lifting secretary of the society. Stop. You are the chairman.
No, my lord.
You are the
I am the lifting secretary.
lifting. Then you say while he was holding the post of lifting secretary of the office society. Stop. Call for the case diary fixing
On 10th of April.
10/4/24. Stop. Considering the facts and circumstances of the case, it is provided that in the event of arrest, the petitioner named above shall be released on interim pre-arrest bail in connection with the above noted case on furnishing bail bond of rupees 30,000?
Yes.
30,000 with one surety of like amount to the satisfaction of the arresting authority, subject of course to the following conditions. Number one, that the petitioner shall appear before the investigating officer within 7 days.
10 days.
Within 10 days, failing which on and from the 11th day, the interim pre-arrest bail order shall have no force. Number two, that the petitioner shall not directly or indirectly make any inducement, threat or promise to any person acquainted with the facts of the case so as to dissuade him from disclosing such facts to the court to any police officer. And number three, that the petitioner shall refrain from committing any similar offences in future of which he is accused or suspected of commission.
Much.
Please, Your Lordship. It is
Yes,
a
Mr. Kotaki.
This case under section 326, 320, 506.
FIR
FIR, Your Lordship will find at page 13, my lord.
30.
Case 9, my lord.
Page 9, my lord, the translated portion, my lord.
Yes.
Allegation is that, my lord, that it is of 3/2/2024, my lord. When his elder son, my lord, Dibujyoti Gogoi, went to the shop at Timonia, Tinia, guys, then Umakanto Chetia, was without attack him with broken backside with a sharp weapon caused injury. As a result, son was severely injured. Some hours after saving his life, we brought to our son to our home, and later on, my wife asked the person.
What injury?
It is a assault by.
You are representing both the petitioners?
Yes.
CD will reveal, my lord, what kind of injury.
Anyway, interim we are giving. If something grave comes,
Yes.
we will obviously consider it.
Yes.
Yes. Heard Mr. P. Kotoki, learned counsel for the petitioner. Stop. Also heard Mr. P. Bhattacharya, learned APP for state respondent. Stop. This is an application under Section 438 of the Code of Criminal Procedure 1973 for granting pre-arrest bail to the petitioners, i.e. Sri Umakanto Chetia and Sri Nobojoti Chetia, who are apprehending arrest in connection with Lahwal PS case number 14 of 2024, registered under section 326, 307, 506, 34 of the IPC. So, all for the case diary fixing
On my lord, 9th of April, my lord.
9/4/2024. Considering the facts and circumstances of the case, it is provided that in the event of arrest, the petitioners named above shall be released on bail or on interim pre-arrest bail in connection with the above noted case on furnishing bail bond of rupees 30,000 each to the with one surety of like amount to the satisfaction of the arresting authority, subject of course to the following conditions. Number 1, 10 days. Number 2, inducement. Number 3, similar offences. Yeah, right? Okay. Yes. Yes.
May I, your lordship? I'm new advocate. This is my first.
I don't think you need to say that. Yes.
This is a pre-arrest bail application under section 438 IIP. Your lordship, kindly have a look on FIR page number 15, annexer as A.
FIR is at which page?
Page 15, my lord. Relevant to
Yes.
page 15.
Yes, read.
Sir Sujit Sarkar, son of late Gopi Sarkar, and Srimati Alpana Sarkar, wife of Sarkar, both are permanent residents of Ganeshpara, Raj Mohan Boropat, Ward number 7, police station Fatashil Ambari, post office Fatashil Ambari, Guwahati 781025, in this district of Kamrup Metro, Assam. To hereby inform you that we are returning a hotel in the name Sarkar Hotel at Fatashil Ambari near Mayur Cinema, Guwahati 781025. Sir, on 14.
I think case diary will be needed in this. They have been very grievously
Yes. When my lord,
assaulted.
victim and my lord, his wife.
Yes, yes.
But Lordship, the way the case is present in FIR is not the true picture of the.
Very well. We will
Picture of
see
the
after the
case.
case diary is called. We are not rejecting your petition today. Call for the case diary. List on, give a short date, Mr. Pathakur.
On 12th of March. my lord.
On 12/3/2024. Yes. Yes. 306.
Yes. Case 11, my lord, after.
Yes.
Lordship, there is a dispute regarding the ingress or egress road.
Dispute regarding?
Ingress and egress road. And for that, my lord, one petition of the DC concerned under section 1. Accordingly, my lord, procedure was carried out. This
One person died.
Yes. Tahira Babi Kumar.
Who is the mother?
mother of the villain.
Mother of the informant.
Mondal, Umra also implicated.
All right. Case diary.
On my lord, 19th of March.
19/3/2024.
Well, protection
Wait for some time. Yes.
plus
376.
FIS page 9, madam.
Page
9.
2016, my lord. Thereafter, my lord, after investigation, my lord, the internal inquiry report has been submitted. I have annexed the copies of the internal inquiry report.
Where is
and,
that?
And that is, my lord,
Page 20. my lord.
page 20.
What does it reveal?
Petitioner is not named in the FIR, my lord. He is not the branch manager. An entire allegation against the branch manager, my lord.
You are?
I am there on that time, my lord, probationary officer, my lord. I have no responsibility regarding the sanctioning and processing of the any loan account. My lord.
Yes.
And what's it, the internal inquiry report, my lord, that is annexure 3, my lord, and categorically.
Who is Tarun Kumar, the branch manager?
Yes, my lord. He against him, my lord, he was.
All right.
My lord.
Mr. Bhattakur, let him appear.
Yes.
Heard Mr. S.K. Jain, learned counsel for the petitioner. Stop. Also heard Mr. P. Borthakur, learned APP for the state respondent. Stop. This is an application under section 438 of the Code of Criminal Procedure 1973 for granting pre-arrest bail to the petitioner, i.e. Sandeepan Paul Chaudhary, who is apprehending arrest in connection with BI within bracket EOPS case number 02/2016 registered under section 120B, 420, 409, 468, 471 of the IPC. Stop. Stop. Call for the case diary fixing
On, my lord, 18th of April.
fixing 18
April.
18/4/2024. Stop. Considering the facts and circumstances of the case, it is provided that in the event of arrest, the petitioner named above, shall be released on interim pre-arrest bail in connection with the above noted case to the, on furnishing bail bond of rupees 30,000?
Yes.
30,000 with one surety of like amount to the satisfaction of the arresting authority, subject, of course, to the following conditions. Number 1, 7 days.
My lord, can it be 14 days?
No.
I'm residing at Kolkata, my lord.
You make arrangement and you come.
10 days.
10 days. 10 days. And number 2, inducement. Number 3, similar offense.
Deeply obliged. Obliged, my lord.
Great, please, Your Lordship. This is
Yes.
the 438 bail application. The allegation against me under section 373, 354, 94.
376.
Yes, sir.
What is the allegation against Sirajul Haq?
Because, my lord, against
Who is he? He is the BDO.
He is not. The BDO has lost this. Earlier BDO has lost this affair, my lord, whose bail application is already pending before Your Lordship. Today is also listed, my lord. And, my lord, regarding the allegation
So
against
this is
the
a cross FIR.
not cross affair. Already allegation is made against the BDO and answer chairman.
We'll take this with that then.
Yes, then. 57.
Hey, intaje matter ase.
Supplementary.
Mr. Borthakur, what is the item of the other 3 matters today?
57, 58.
Itar lago it much. Yes.
438 application.
Yes.
FIR. One FIR lost by the officer in charge. And
One FIR by?
officer in charge and OC, or by police station. What happened, my lord, in this case, my lord, in charge of the Komarkosi outpost, my lord, informed the Nalbari police station that 100 person, my lord, stopped a LMU car and assaulted 4 persons. Suspected,
You are for whom? One person
I am for 1 person.
with bamboo sticks and lathi.
That's it. Suspected to be cow thief at about 1 p.m., 1 a.m., midnight.
And the second FIR is
Second
at
FIR lost
15.
by the public, my lord. Against the 4 person, my lord, please.
You have not been named in the
Name
FIR.
not name accused, my lord. Not-
Yes, Mr. Borthakur, let him appear.
Here.
Heard Mr. AJ Das,
Yes,
learned counsel for the petitioner. Stop. Also heard Mr. P. Borthakur, learned APP for state respondent. This is an application under section 438 of the RPC praying for granting pre-arrest bail to the accused petitioner, i.e. Sri Khogen Kolita, who is apprehending arrest in connection with Nalbari PS case number 32/2024 registered under section 120B, 143, 144, 341, 326, 307, 436, 353, 427 of the IPC. Stop. Call for the case diary fixing
On 8/4, my lord.
8/4/2024. Stop. Considering the facts and circumstances of the case, it is provided that in the event of arrest, the petitioner named above shall be released on interim pre-arrest bail in connection with the above noted case on furnishing bail bond of rupees 30,000
Yes.
with one surety of like amount to the satisfaction of the arresting authority, subject of course to the following conditions. Number 1, 10 days. Number 2, inducement. Number 3, similar offense.
Wait, please, Your Lordship.
Yes, Mr. Das?
My Lord, 438 application, my Lord. FIR
Yes.
is at page number 15.
Yes.
May I read the FIR?
Yes.
With due respect, I beg to state that on 13/2/2024 at around 5 p.m., I and my son, Sohail Akan, went to Belbury for purchasing betel nut along with rupees 3 lakhs. Unable to purchase the betel nut, when I and my son were returning home with the money, at around 9 p.m., the above named accused persons armed with lathi, rod, dagger, etc. near the bank.
Who are you? For how many? One
the
or
accused- all the accused persons.
or all?
Yes.
Total 9.
Yes, my Lord. No,
8.
8, my Lord.
8. You are for the 8.
Yes.
Okay.
My Lord, the allegation is that, my Lord, the petitioners had assaulted the informant and his son and also robbed around rupees 3 lakhs. The FIR was registered under section 147, 148, 149, 379, 320, 307. My Lord, the actual fact is that, my Lord,
Informant himself has filed the FIR.
yes.
Yes, informant has filed it.
Well, it may not be. Let them appear then, Mr. Thakur.
Yes. That's saying also an amount of rupees 3 lakhs. Anyway, my Lord, let them appear.
Let them appear. Heard Mr. S. Das, learned counsel for the petitioners. Stop. Also heard Mr. P. Borthakur, learned APP for state respondents. Stop. This is an application under section 438 of CRPC, praying for pre-arrest bail to the petitioners, namely, copy at page 2, namely 1, 2, 3, 4, 5, 6, 7, and 8, who are apprehending arrest in connection with South Salmara Police Station case number 36/2024, registered under section 147, 148, 149, 379, 325, 326, 307 of the IPC. So, call for the case diary fixing after
On 5/4, my Lord.
fixing on 5/4/2024. Stop. Considering the facts and circumstances of the case, it is provided that in the event of arrest, the petitioners named above shall be released on interim pre-arrest bail in connection with the above noted case, on furnishing bail bond of rupees 30,000 each with one surety of like amount to the satisfaction of the arresting authority, subject of course to the following conditions. Stop. 1, 2, 3.
Highly obliged.
Yes.
My Lord, this is an application under section 438. Lord, in this case, the petitioner is a daily wage earner and the father of my Lord, the
307.
My Lord.
Yes, FIR.
As per FIR, though it is, my Lord, the case is based under section 326 and 307, my Lord, but the offense is not like this, my Lord. There is no grievous hurt, my Lord. They were, my Lord, treated in the community health center, my Lord.
Who filed the FIR?
It is, my Lord, by the villagers, not by the victim. Till that, my Lord, the victims have not lost any FIR, my Lord. And even, my Lord, the case is registered after 8 days, my Lord. A
6
village-
stitches.
My
Thakur.
Yes, my Lord. Otherwise, my Lord, why victims has, because the villagers, my Lord, came to, who were, my Lord, witnesses of the incident, they have lost the FIR.
Not by the victim, my
Let him
Lord.
appear then. Your MS Thakuria.
NS
Heard MS N.S. Thakuria, learned counsel for the applicant. Stop. Also heard Mr. P. Borthakur, learned APP for state respondent. Stop. This is an application under section 438 CRPC 1973 for granting pre-arrest bail to the petitioner I, Sri Amal Das, who is apprehending arrest in connection with Polasbari PS case number 55/2024, registered under section 341, 326, 307 and 506 IPC. Dot. Call for the case diary fixing 8/4/2024. Stop. Considering the facts and circumstances of the case, it is provided that in the event of arrest of, the petitioner named above shall be released on interim pre-arrest bail in connection with the above noted case on furnishing bail bond of rupees 30,000 with one surety of like amount to the satisfaction of the arresting authority, subject of course to the following conditions. 1, 2, 3.
Deeply obliged.
Thank you. My Lord, petitioner before your Lordship filed, my Lord, one application
Yes.
at page 25. Praying for, my Lord,
For recross examination.
the cross-examination.
That was not allowed.
Not allowed, ma'am.
Against that you have come.
Yes, ma'am.
Learned Trial Court has passed an detailed order, why that petition already case is fixed for argument 2-3 times. Only the ground they have taken that.
We'll issue notice then.
Otherwise, case is already fixed.
When is it fixed?
Argument. 3-4 times during argument stage they have taken time.
My Lord, in this regard, I have also brought some judgment of the Honorable Supreme Court. My Lord, it was fixed
All
on,
right,
my Lord,
we'll,
1/3/2024.
this is an application under section 482 of CRPC, read with section 397 of the said court, setting aside and quashing the impugned order dated 17/2/2024 passed by the learned additional session judge Hailakandi in session case number 26 of 2018, allowing them to recross examination of the PWs 1, 3 and 8 of the said case for the interest of justice. Stop. Allowing and disallowing.
Disallowed, my Lord.
Disallowing. Issue notice returnable with 2 weeks. So respondent is only state of Assam.
My Lord.
No private respondent.
My Lord. The GR case.
Mr. D. Das accepts notice on behalf of the state of Assam. Extra copies within the course of the day. List on a list after 2 weeks on a date to be fixed by the registry.
My Lord, in the meantime, my Lord, my Lord,
Next.
otherwise, my Lord, case will go on.
Next.
But I may be allowed to go on judgment of the Supreme Court, my Lord, in this
Next,
point.
next. We can shorten the date, otherwise we are not granting you anything today.
Obliged, my Lord. One thing, my Lord, returnable date, my Lord, interim order may be considered, my Lord, may be observed, my Lord.
Next. All right, next.
Obliged.
This is the joint petition filed by
It
the,
leftover, is it? Yes.
no, this is the joint petition filed by the victim and the accused lordship.
Joint petition.
Joint petition.
Settlement.
My lord. And
Posco-
they have already,
Posco case,
no,
Posco-
Posco is not, trial is going against the present petitioner lordship under section 376 and 506. And so far,
We will require that, I think.
Lordship, I just point out what has happened. Rupees 60 lakh of counterfeited notes. I'll read the FIR. Were found in the vehicle, and in the next vehicle we are going. Now, Lordship, let us presume it is found from my possession, Lordship. Now the scheme of 489 A, B, and C are allegedly allegations are in 489 A, B, and C. Now 489 A is for manufacturing counterfeited notes. That is not the allegation. 489 B is using counterfeited notes. That is also not the allegation. 489 C, possessing of counterfeiting notes. That is the allegation. Let us presume even if to be true.
But it was recovered from the other vehicle.
Other vehicle.
He was also
Ma'am,
present at that. I would just like to point out one thing before we say, because along with all other accused persons, he was also at that point of time, and from their position, those notes were recovered. But from the statement of the other accused person, he stated that he is the persons. He, my lord, on behalf of the other accused persons, he, my lord, arranged the vehicle for other accused person. And for that, my lord, the other accused person assured him to pay an amount of rupees 10 lakhs. And the accused also, my lord, in his statement stated in that manner. So directly, my lord, he is not involved in the, my lord, in relation to the, in respect of the, my lord, that is the, I said I am not saying anything about in that respect, my lord. Considering only the length of detention, your lordship can be considered, my lord. Otherwise, from the statement of the other accused.
How long?
62 days today.
62
And
days.
moreover, Lordship would see if possession of counterfeited notes.
Well, only on the
4488
ground of length of detention, other, my lord, statements.
As per the statements, he is the person
He
who
is
had
the person who arranged the vehicles for the
vehicles
other accused
for the
persons.
other accused person.
And while, my lord, they both are, my lord, on the way, then one of the accused persons stated that we are bringing some of the fake notes in our briefcase. I will provide you a rupees of
all right.
amount of rupees 10 lakh.
Mr. Bora, where is your name reflected in the
FIR. FIR, Lordship would see page 12, second paragraph, around 10th line, 1, 8, 9,
Yes.
9th line.
Vikas Gogoi.
Vikas Gogoi, serial number 2.
Serial number 2.
Lord, my lord, during, my lord, recovery
All right.
of that,
Third, Mr. B.P. Bora, Learned Counsel for the petitioner. Stop. Also heard Mr. P. Borthakur, Learned APP for state respondent. Stop. The case of the No, Bonita. This is an application under Section 439 of the Code of Criminal Procedure 1973 for granting of regular bail to the petitioner, i.e. Vikas Gogoi, who has been arrested on 5/1/2024 in connection with Manja PS case number 1/2024 registered under section 120B stroke 489A stroke 489B stroke 48 489C 48 নহয় দেই stroke 34 of IPC. Stop. The case of the prosecution is that on 4/1/2024, upon receiving an information that a group of miscreants are about to smuggle a huge amount of fake Indian currency note from Nagaon side towards Manipur, an operation was conducted whereby one vehicle bearing registration number AS01FN1856, which was coming from Bakalia side, was apprehended, and upon search a total of rupees 60 lakh of fake Indian currency was recovered from the said vehicle. Stop. Another vehicle bearing registered number AS01EY9171 was also detained by the said officers and later on handed over to the jurisdictional police station in connection with this case. Stop. Mr. B.P. Bora, Learned Counsel for the petitioner, submits that the petitioner was not traveling in the vehicle from which the fake currency
he
notes...
was traveling in that vehicle along with the other accused.
Not in that. He was traveling in the other one, according to him. Correct, Mr. Bora?
Yes.
That was your submission?
That is my contention. That is the thing.
That he was not traveling in the vehicle from which the fake currency notes were recovered. Stop. He further submits that he was traveling in the second vehicle, which also was seized, which also was stopped and handed over to the jurisdictional police station. Stop. Next para. Mr. P.P. Borthakur, learned APP, on the other hand, strongly opposes the prayer for bail. Stop. He submits on the basis of the statements recorded under Section 161 CRPC that there are materials to indicate that it is the petitioner who has arranged for the vehicle in which the fake currency was transported and recovered. Stop. He further submits that the investigation has substantially progressed and the statements of the witnesses have already been recorded. Stop. Next para. I have heard the submissions made at the bar and have perused the materials available on record. Stop. It appears that the petitioner has been languishing in jail since last 62 days. 62 days. Stop. It further appears that the petitioner has already been interrogated and his statements have been recorded, correct?
Yes.
And his statement has been recorded. Stop. Considering the length of delay and the totality of the matter, this court is inclined to grant bail to the petitioner. Stop. Accordingly, it is provided that the accused petitioner named above shall be released on bail in connection with the above noted case with a bail bond of rupees 60,000?
Yes.
Of 60,000 only, with one surety of like amount to the satisfaction of the learned.
Learned CGM, Karbi Anglong.
Learned CGM Karbi Anglong, subject to the following conditions. Number 1, the accused petitioner shall cooperate with the investigating officer as and when required. Number 2, inducement. Number 3, refrain from such activities. Return the case diary. The bail application stands disposed of.
Deeply obliged.
Yes, Mr. Borthakur.
He was called for your
Not received. Await CD. List again on.
From Dorong Marathon 25. Oh, yes.
4/4/2024 interim. If any, shall continue till then.
obliged.
Also, CD not received.
Await CD. List again on.
This is from Sonapur, Malad.
Yes, date.
20.
23/2024. Interim order passed earlier shall continue till then.
Here your Lordship, CD was called for.
CD available. Yes. This is
Petitioner is on interim, your Lordship.
379 and 443.
Lordship. In fact, your Lordship, this was FIR was lost by your Lordship, his fiancé. Fiancé. There are some,
Fiancé.
Your Lordship, some dispute between them. Ultimately, she lost this FIR, your Lordship. And after that, your Lordship, they compromised the matter, your Lordship, to that effect, your Lordship. And affidavit has also been sworn.
This he has appeared.
Well, APS statement recorded, and as per 164 also she admitted she is age about 25 and she has consented. There is nothing.
And
the assurance of
Then there is no adverse material.
consented, that is that, but subsequently he refused because of that.
That is a different thing.
Regarding that,
Right. Heard Mr. S. Borthakur, learned counsel for the petitioner. Stop. Also heard Mr. K.K. Parashar, learned APP for the state respondent. Stop. This is an application. This is an application under Section 438 of CRPC for granting pre-arrest bail to the petitioner, i.e., Pragyan Chutia, who was apprehending arrest on. Who is apprehending arrest in connection with Dibrugarh Police Station case number 468/2023 registered under section 376-493-325 of IPC. Stop. The case diary as called for is placed before this court. Stop. It may be mentioned that by order dated 12/12/2023, this court granted the privilege of interim pre-arrest bail to the petitioner subject to conditions. Stop. Next para. Mr. K. Parashar, learned APP, submits that the case diary shows that the petitioner has appeared before the investigating officer, and his statement have been recorded under section 161 CRPC as per the interim pre-arrest bail granted earlier. Stop. There is no adverse report against the petitioner from the IO. Stop. This court finds that custodial interrogation of the petitioner may not be required in the interest of the ongoing investigation into the case. Stop. Accordingly, the interim pre-arrest bail granted be the order dated 12/12/2023 is hereby made absolute, subject to the following conditions. Number one, that the petitioner shall cooperate in investigation as and when required. Number two, inducement. Return the case diary. This disposes of the anticipatory bail application.
Deeply applied.
Disposed of.
Here CD not available. It is an interim.
Await CD. List again on
Crime branch on 27 Malad.
27/3/2024. Interim order passed earlier shall continue till then.
Very much.
Yes. Yes.
The 438 application, my lord.
CD, Mr. Pasha?
CD available, Malad, but here, Malad, though PM report is available, but FSL is not available. And as per the opinion, Malad, in the PM report, Malad, it's pending till receive the.
You need that?
Malad, that FSL is not available at this.
So next week? You are on interim?
No, my lord, no interim.
302, because of that, Malad, body was found in the railway line, Malad, that is there.
Next week? When? Friday?
Malad,
Can it be on, my lord, 15th?
Yes.
15th.
Reminder for the
FSL report.
FSL report. Stop. List this matter again on 15/3/2024.
I'm obliged.
Yes, Mr. Bora.
438 application, my lord. I am on interim.
Yes.
Case diary was called for.
Yes.
So, between the two constable, my lord, lady constable and her. The judge will find the gist of the FIR at page 26.
Page 26?
Yes. Initially, a complaint has been lodged. Subsequently, from that complaint, my lord, the FIR has been registered.
Yes.
Page 26.
Yes.
Basic allegation is that the concealing the fast marriage, petitioner has married woman.
I didn't get you, Mr. Bora.
Concealing his first marriage, my lord.
Acha,
He has again entered into the marriage
Okay.
of the.
Yes.
That's
Without
the-
disclosing about the first. Yes.
His case is that he has already been divorced. That is
This is FIR is registered under?
basically, my lord, 498A, 312/13, 395, 498E.
Yes.
His appeared,
I'll make it absolute.
long statements have been given by him and denied allegation of marriage.
Heard Mr. A.M. Bora, learned senior counsel, assisted by Mr. B.P. Bora, learned counsel for the petitioners. Stop. Also heard Mr. D. Das, learned APP for state respondent. Stop. This is an application under section 438 of CRPC for granting of pre-arrest bail to the petitioner, right? One petitioner.
Right.
To the petitioner, I. Pratap Senar, who is apprehending arrest in connection with Silchar PS case number 2470/2023 registered under section 312, 313, 417, 494, 495, 498 of IPC. Stop. The case diary as called for is placed before this court. Stop. It may be mentioned that by order dated 12/1/2024, this court granted the privilege of interim pre-arrest bail to the petitioner subject to conditions. Stop. Mr. D. Das, learned APP, submits that the case diary shows that the petitioner has appeared before the investigating officer and his statement have been recorded under section 161 CRPC as per the interim pre-arrest bail granted earlier. Stop. It appears, next paragraph, it appears that the petitioner is cooperating with the investigation and the investigation has substantially progressed. Stop. As such, this court finds that custodial interrogation of the petitioner may not be required in the interest of the ongoing investigation into the case. Stop. Accordingly, the interim pre-arrest bail granted by the order dated 12/1/2024 is hereby made absolute, subject to the following conditions. Number one, that the petitioner shall cooperate in the investigation as and when required. Number two, the inducement. All right. Now, Vanita, return the case diary. This disposes of the anticipatory bail application.
Map
376.
Yes, Lordship. And Lordship, in this case, notice was issued. I have taken step and Lordship opposite.
We're not giving any time.
My lord. Otherwise, my lord, there is nothing, my lord.
Sorry?
My lord, 376 allegation is there along with 511. At them, accused has appeared, my lord. Statement recorded.
Senior.
Case diary?
Case diary is not there.
Await CD. List again on. Are you on interim?
No, Lord. No, Lord.
If short date is not on interim.
20th of March.
Next. Yes, Mr. Prashad.
In this is a search-sheeted case, my lord. Scan copy not yet received, my lord.
You were on interim?
No, madam. But I have enclosed all the documents.
Earlier, scan copy of LCR was called for, not yet received.
It was not called for.
This is AB.
AB.
What is the offense?
376 as well.
376. Who is apprehending arrest in connection with Pokrajar PS case number 143/2021 registered under section 406, 420, 408, 409, 468 of IPC. Stop. The case diary as called for is placed before the court. Stop. It may be mentioned by which order, Mr. Bhuya?
7-9.
7/9.
2020.
It may be mentioned that by order dated 7/9/2023,
Yes.
this court granted the privilege of interim pre-arrest bail to the petitioner subject to conditions. Stop. Mr. P. Borthakur, learned APP, submits that the petitioner has appeared before the investigating officer and his statement has been recorded under section 161 CRPC.
Regarding that, I got only verbal instruction because that.
And
that is
as
not
per
available.
the interim pre-arrest bail granted earlier. Stop. Then next para. Considering that the petitioner is cooperating with the investigation and the investigation having substantially progressed, this court finds that custodial interrogation of the petitioner may not be required in the interest of the ongoing investigation into the case. Stop. Accordingly, the interim pre-arrest bail granted by the order dated 7/9/2023
Yes.
is hereby made absolute subject to the following conditions. 1, 2, Didiba. Return the case diary. This disposes of the anticipatory bail application. Here. See? Again. The idea was, I was hoping I could have dictated this order inside, but there's a scarcity of stenographers. I was waiting, but there was no one to take dictation, so I could not. Anyway, 57 is the, I think 57 was earlier item number 2020, right? That is where Mr. Chaudhary was appearing, the president.
Yes, President Mandiranch.
Mr. Bora, your client is the BDO.
BDO, Eden BDO.
And the other one is the owner of that firm which received.
Yes.
Right? Okay.
And now today, my lord, item number 20.
That will come little later.
And regarding my lord, item number 29, my lord, the FIR I have lodged immediately.
That will come little later. You are appearing in that item?
No, my lord. That has come up for motion, my lord. Against whom I have filed the FIR, my lord. As a BDO, my lord, he has come for the bail, my lord.
Just take your seats, Mr. Counsels. In item number 57, we first लिखेंगे.
I have objection in all those matters,
Yes.
including today's matter also. my-
We've heard you all.
Yes.
You see, the idea of bail is not punitive.
Yes.
Correct.
But my lord,
But here they have already given their
Yes.
statements. I have read their
Yes.
statements. They have admitted. But that itself doesn't mean. Anyways. Heard Mr. H.R.A. Chaudhary, learned senior counsel, assisted by
A.M. Ahmed.
Mr.
A.M. Ahmed.
A.M. Ahmed. Mr. Bora, I shall just take a 5 minutes break and come back. There is nothing. Item number 57. Order to accept. Heard Mr. H.R.A. Chaudhary, learned senior counsel, assisted by
A.M.
Mr. A.M. Ahmed, learned counsel for the petitioner. Also heard Mr. P. Borthakur, learned APP for the state respondent. This is an application under section 438 of the Code of Criminal Procedure 1973 for seeking pre-arrest bail for the petitioner I. Kulsuma Talukdar, who is apprehending arrest in connection with Bagbor PS case number 81 of 2023, registered under sections 120B, 420, 406, 409 of IPC. The brief case of the prosecution is that one Pallavi Das BDO, Pandya Development Bank, on 14/12/2023 lodged an FIR before the officer in charge of Bagbor Police Station, inter alia, alleging that between 35/2023 to 29/9/2023, substantial amount of funds under 15th Finance Commission, which was earmarked for maintenance of PWSS, was transferred directly to a vendor, namely Aryan Enterprise, through Public Financial Management System. It is further alleged in the FIR that the said transfer was in violation of the established protocols outlined for utilization of 15th Finance Commission Fund. Stop. It is also alleged that after coming to know about the said anomalies, the first informant had informed the Chief Executive Officer of Borpeta Zilla Parishad in writing, and an inquiry was conducted by the CEO of Borpeta Zilla Parishad by visiting Mandya Development Office Block on 12/12/2023, wherein it was revealed that the transactions were in violation of government guidelines and were not supported by relevant documents, and therefore it is suspected that the government funds have been misappropriated. Stop. Mr. Learned Senior Counsel for the petitioner has submitted that the petitioner is an elected representative of Mandya Anchalak Panchayat, and he or she, and she is the chairman of the said Mandya Anchalak Panchayat, and she is in no way involved in transferring the said funds. Stop. On the other, then you write, Mr. P. Borthakur, learned APP, on the other hand, submits that the case diary reveals that the investigation officer has collected materials which clearly implicates the petitioner. Stop. He further submits that the allegations are leveled against the petitioner are grave. Stop. Then you say, I have considered the submissions made by learned. I have considered the submissions made at the bar and have perused the materials available on record. Stop. It appears no. It may be mentioned that by order dated 8/1/2024, this court granted the privilege of interim pre-arrest bail to the petitioner, subject to conditions. Stop. Next para. It further appears from the case diary that the petitioner has appeared before the investigating officer as per the interim pre-arrest bail order. Stop. It further appears that the statements have been recorded under section 161 CRPC. Stop. A perusal of the aforesaid statement indicates that the petitioner has admitted that the petitioner, along with the other co-accused, has misappropriated government funds in the absence of Pallavi Das, the then video. Is she still the video?
Still his.
In the absence of Pallavi Das, video, Mandya Development Block. Stop. That is the only they have admitted, isn't it? Then you say, the investigation appears to have progressed substantially. Stop. Next para. Undoubtedly, the offence is grave. But that alone cannot be a decisive ground to deny bail to the petitioner. Stop. There appears no adverse materials collected by the investigating officer as regards the antecedent of the petitioner. Stop. Next para. The law with regard to grant of bail is now well settled. Stop. As early as in the year 1978, the Honorable Supreme Court in Gurcharan Singh versus State reported in 1978 1 SSC at page 118 laid the following criteria for grant of bail. The quote paragraph 22, 24, or mark for yourself. Then you say, next para. In a detailed judgment, the Honorable Supreme Court in Siddharam Tatlangapa Matre versus State of Maharashtra and others reported in 2011 1 SSC 694 while relying upon its decision rendered by its constitution bench in Gurbakh Singh Tibba versus State of Punjab within bracket 1982 SSC 6565 laid down the following parameters for grant of bail. In quote unquote paragraph 111 112 my orange packet. Stop. Next paragraph. Considering that the petitioner has cooperated with the investigation, this court finds that custodial interrogation of the petitioner may not be required in the interest of the ongoing investigation into the case. Stop. Accordingly, the interim pre-arrest bail granted with a order dated 8/1/2024 is hereby made absolute subject to the following conditions. Number 1, that the petitioner shall not leave the jurisdiction of the trial court without prior permission. Number 1. Number 2, that the petitioner shall cooperate in the investigation as and when required. Number 3, that the petitioner shall not directly or indirectly make any inducement, threat or promise to any person acquainted with the facts of the case so as to dissuade him from disclosing such facts to the court or to any police officer. Stop. Return the case diary. This disposes of the anticipatory bail application. Stop. Any other condition, Mr. Bhattakur? That is sufficient? All right. Now, in item number 56, in item number 7, sorry, in item 58, naam to change ho jabo, and here
interim order also.
Yes. I
11-1.
Just 1 second. এই যে প্রেসিডেন্ট বিলি কোয়েশ্চন হয় ইয়াত হ'ব BDO Mandya Development. Sorry, here the petitioner is
IC BDO.
In charge BDO. Mandya Development Block. Okay. President Nohai. And then the interim order is dated 11/3.
1.
Sorry, 11/1/2024. Okay. The rest I think all same.
How like?
And 59. In 59, he is the proprietor.
SS Aryan Enterprise.
Yes. Proprietor of MS Aryan Enterprise. Paragraph 4. Okay. And interim dated 22/1/24. This 3. Now, which is the other case?
Other case is FIR is different.
FIR is different.
Complaint case was filed initially.
Complaint is filed by the BDO.
Page 11, my lord. Your lordship may kindly peruse page 11, my lord. Here, my lord,
Here the case diary is not there.
Case diary is not there. Here, my lord, Safiur Rahman, my lord, he is the, my lord, proprietor of area. He is also one of the accused. And his brother, my lord, Shirazul Haq, as per this complaint, my lord, the my lord, in charge BDO has stated that as per he verbally instructed the accused number 1, and thereafter he transferred those amount to the account of Safiur Rahman.
This FIR is relating to the same transaction, correct? But a different narration.
Yes.
Isn't it?
Yes.
This is filed by one of the person whom we just granted anticipatory bail.
Number 58.
In this case, my lord, complaint is lodged on 28/12/23.
But here you don't have the case diary.
Case diary is not available.
So have it next week, then we'll consider.
Yes,
In that I will cooperate 37 days after loss FIR.
that because the entire amount is transferred to the account of the accused number 2.
Heard Mr.
by-
Mr. S.S.
S. Islam.
S. Islam, learned counsel, appearing for the petitioner, stopped. Also heard Mr. P. Borthakur, learned APP, Assam, appearing for the state respondent. This is an application under section 438 of CRPC 1973 for granting pre-arrest bail to the accused petitioner, i.e. Sirajul Haq, who is apprehending arrest in connection with Bokbor Police Station case number 06-2024 registered under section 120B 409-420 IPC. Stop. Call for the case diary fixing?
On my lord, 19th of March.
19/3/2024. Stop. Considering the facts and circumstances of the case, it is provided that in the event of arrest, the petitioner named above shall be released on interim pre-arrest bail in connection with the above noted case on furnishing bail bond of rupees 30,000 with one surety of like amount to the satisfaction of the arresting authority, subject of course to the following conditions. Number 1, that the petitioner shall appear before the investigating officer within 7 days, failing which on and from 8th day the interim pre-arrest bail order shall have no force. Stop. That number 2, that the petitioner shall not directly or indirectly make any inducement, threat or promise to any person acquainted with the facts of the case so as to dissuade him from disclosing such facts to the court or to any police officer. And number 3, that the petitioner shall refrain from committing any similar offences in future of which he is accused or suspected of commission.
Obligation.
F first. Parted. Orders been to which one, eh? Mr. Tiwari,
Yes, without.
since this will take time,
It will take time.
shall I finish the orders and
Bail
then
hearings, very well. As better.
let us finish the list?
Because
Mr.
if I
Dasgupta,
start
let me.
without
Only thing is that at 2 o'clock there is another part heard fixed. So once that is done, then we will call yours.
In all likelihood, my lord, if my case begins, I will take rest of the time till today, till this evening. As
You
a
want
matter of
another
license.
date?
Huh?
Should we have it on another date then?
My
Because
lord, I am prepared, subject to my lord's convenience and subject to my lord's roster.
I am not sure how much time that other matter will take, which is fixed at 2 o'clock, where Mr. Tushar Mehta is supposed to give reply
Your
today.
Lordship may kindly fix it on Monday.
Monday? Should we have it on
Sir,
Tuesday, a hearing
any
day? That
day.
would be better, I think. And we will say at 2 then. Since it's a part-heard matter, let us fix it at 2 o'clock on Tuesday. Mr. Tiwari?
My lord,
At 2 o'clock on Tuesday?
Tuesday is... My lord, there is only one difficulty on Tuesday. There is a matter fixed before...
When do you want? Tell me.
Court number 1 also the matter is fixed on Tuesday.
Thursday?
Huh?
Next
19,
Thursday?
19, my lord, is...
19th is a Thursday, Bora. Right, hearing remain inconclusive. List again on, not this Tuesday, next one. On 19/3/2024 at 2 p.m. At 2 p.m. Yes. Yes, Mr. Borwa, that's part-heard matter.
Part-heard matter, Lordship. Today it was fixed for giving the written argument. I have prepared it.
And the other side?
My senior is coming.
Has Mr. Kayal has he given his reply in this matter?
Yes, Lord.
Arguments are over. Only for written arguments today the matter was fixed. So your written arguments are ready?
Sir, he's coming. Sir, he's coming.
He's already there. Only for written arguments, right,
Yes,
Mr.
Lord.
Kayal?
I am submitting it.
All right. Then I will note that and close it. Parties have submitted, for hearing concluded, parties have submitted written arguments, which is kept on record, reserved for judgment. Let us see if we can. আৰু এটা আছে এই আৰ্গুমেণ্টছ তেওঁলোকেও দিব এটা বেলেগ বৰ্ডত বান্ধি আৰু এইটো
Worship,
Yes.
there was one more matter.
Yes.
That is WPC number 3965 of 2021. Worship have asked us to keep the written submission in prior to the matter. It is listed on 12th. So can we submit?
Just put, can you put the, yes, the writ petition number on top? And that is fixed when?
On 12th.
Can you just mention the date, please?
I'll submit on that date.
No problem. All right.
Worship.
Mr. Borwa, you give it to my... To Belek case. Yes, Mr. Sahewala.
This is a matter for passing of an FIR. My lord. What happened, my lord? The response number 2.
FIR is 420-406.
My lord.
Where is the FIR?
Time to.
Page 35?
Yes.
Yes.
My lord, before that, I am just the facts, my lord.
It's just one.
Response number 2. Petitioner is a cement dealer,
Yes.
my lord, in Guwahati. The petitioner, the response number 2, purchased cement by various invoices of 38 lakh and odd. And he issued a check. The check, I have deposited a check, my lord, that bounced. Thereafter notice was issued. When notice was issued,
Petitioner is what? What dealer?
Cement dealer.
Cement dealer.
Cement dealer.
And
I have got the invoices, my
he
lord.
had issued checks
Check.
to the suppliers.
Supplier, my lord.
And those got dishonored.
That was bounced. That was bounced. And now the...
Where is 420 attracted?
How I do not know, my lord. These P are taken always. 139 says, my lord.
This we are noticing 420, 406 are just added when the basic ingredients of deception, inducement, entrustment, all are missing.
Missing, my lord. And 139 is there, my lord. He can take a plea, my lord, there. Until it's contrary, my lord, it is presumed, my lord. Check is presumed to be correct. So let them prove him, my lord, that something is there, sir. 139 of the NI Act, my lord, is very clear, my lord. There are several judgments also.
Here the offences are under 120B,
Yes.
468, 420, 406.
Yes.
Correct?
Correct.
Let us have a look at the FIR.
Yes, ma'am. I have the honor to state that since December 17, first week of February 18, I was in Margherita Revolution Center, Margherita District, Assam, due to my mental disorder. On 28/3/23, one of my checkbook of Union Bank, Dibrugarh branch, to against SB number so containing check number so etc. was lost. Clear, my lord. And the matter was reported to bank authority to stop payment of check of that checkbook. Nowadays, the said all is not acceptable by the bank due to the core banking system, and all the subsequent bank checks books are made for present core banking system, and the checks are MIC check. On 18/5/20, I have come to know that one leaf of the stolen checkbook bearing number so was forged and manipulated to the extent of rupees 38,27,200, and the deposit in my aforesaid account to withdraw the said amount by Sri Sanjay Kumar Jain, son of so-and-so of Yos Enterprise at AK Raja Road, Rihabari, Guwahati, Assam, with the conspiracy of others.
420 on the face of it is not made
my lord,
out.
case. And 139, my lord, NIA Mr. Rasul see if he has something, he can take a plea there.
IPC.
Yeah, IPC. This is just to avoid, my lord, the 138 case, my lord, he has filed it.
Who is on the other side?
He is not, my lord, not appearing, it appears.
The office note indicates no counsel has entered appearance on behalf of respondent number 2.
Yes.
But AD card has received back. Service is complete.
Service complete, my lord. Because he went to my lord because 138, my lord, always this plea is taken. My lord, many cases, my lord.
One second, Mr. Saharwala.
Yes.
120B, right? Punishment of criminal code.
Conspiracy, criminal code.
With whom? What conspiracy? How many accused?
Only one, my lord.
Where is conspiracy here?
My lord, it is a
Then 468.
468 forgery, my lord. His signature is there, my lord. If he disputes his signature, he can take plea, my lord, before the case. Signature is, my lord, virtually not disputing it.
You're right, he hasn't said that the signature has been forged. He says his signed check was lost.
He said, my lord, but he has not said that signature has been, he said that check has been forged. But that will be proved in the NIA case, my lord. That is why 139
So,
is
463, the ingredients is that the basic elements of forgery, the making of a false document or part of it, and such making should be with an intention. That is lacking again.
Lacking, well,
correct?
yes.
Because it is not that he forged the signature. Yes. Then
420 is also not there, madam.
420 absolutely not there. 20 and breach of trust.
Yes.
What entrustment?
Cheating also not there.
Right, you're right. Third, Mr. G.N. Sahewala, Learned Senior Counsel, assisted by MSG Duggar, DU. DUGA. Also heard State Mr. D. Das, Learned APP for the State Respondent. Though service in respect of respondent number 2 was completed, 2 stands completed, comma, none appeared for respondent number 2. Now, this is an application. This is a petition under
Section 42.
This is a petition under section 482 of the Code of Criminal Procedure seeking quashing, right?
My lord.
Seeking quashing of the FIR filed, FIR dated 19/5/2018.
Yes.
In connection with Dibrugarh PS case number 713/2018 registered under section 120B/468 420 406 379 of IPC. 379 was also given. No.
Not there, I think.
Why 379 is added in the cost?
No.
379
Not there,
Not there.
Not there. I'm sorry.
Stop. The case of the prosecution is that the informant on 19/5/2018 filed an FIR alleging that he lost his signed checkbook, and though the matter was reported to bank authority to stop payment, comma, on 18/5/2018, he came to know that one leaf of the said stolen checkbook bearing 101362 was forged and manipulated to the extent of rupees 3827,200 and deposited in his bank account to withdraw the said amount by the petitioner. Stop. It is further alleged that in this manner he has been cheated by the petitioner. Stop. Mr. Jian Sahewala Lalit Senior Counsel submits that the ingredients of the sections alleged, ingredients of the offences alleged in the FIR are lacking on the body of the FIR, and hence no criminal offence whatsoever is made out against the petitioner. Stop. Mr. D. Das, learned APP, has no instructions to oppose the said petition. Stop. I have heard the submissions made at the bar and have perused the materials available on record. Stop. The FIR dated 19/5/2018 is reproduced hereunder for ready reference. Stop. Page 35 to quote unquote. Thank you. On the basis, then you write, on the basis of the aforesaid FIR, a case was registered under section 120B, 468, 420, 406 IPC. So, section 120B, 468, 420, 406 is quoted hereunder for ready reference. Take it over, quote query. Then you say. In order to attract 120B, there has to be two or more persons agreeing to do an act which is illegal. Stop. There is, then you write, in the present case, the informant has not named anyone else except the petitioner, except the present petitioner. Stop. Accordingly, 120. Accordingly, there are no materials for criminal conspiracy. Stop. Then you write. Next para. Similarly, in respect of section 468, the basic elements of forgery, which is. Yes, Mr. Mahajan.
My lord, possibly, my lord, 326 would not be applicable. 323 only, my lord, desiderated loans. That two policemen badly beaten up in custody. 323. 323. Available of possibly, my.
Yes, Mr. Das.
Yes, well, so far, when the medical report is concerned,
yes,
the wound is described as lacerated wound, and 3 stitches have been given. 3 stitches.
3 stitches.
Not
and he was treated as outdoor patient.
So that means not that.
326 may not come.
May not come.
Is correct. And
all right. Heard Mr. B.M. Mahajan, learned counsel for the petitioner. Stop. Also heard Mr. Mr. D. Das, learned additional public prosecutor for the state of Assam. Stop. This is an application under Section 439 of the 439 of CRPC for granting bail to the accused petitioner, i.e., Rinal Medhi, who has been arrested on 3/3/2024 in connection with Bokhisto Police Station case number 845 of 2023. Registered under Section 294, 323, 326, 384, 427, 506, 34 of IPC. The case of the prosecution is that on 29/12/2023, the informant lodged an FIR before the officer in charge of the jurisdictional police station alleging inter alia that on 28/12/2023 at around 10:30 p.m., the informant and one of his friends, namely Pulin Deka, after completion of their duties, went out to have their dinner in Suresh Dhaba, situated at Bokhisto Balughat, and while the informant went to a darker place for urination, three boys came there and started to beat both the informant and his friend and caused severe head injury upon the informant and also threatened them with dire consequences. Stop. It is further alleged that the accused persons also snatched away gold chain of the informant and broke the mobile handsets of both the informant and his friend. Stop. Mr. Mahajan, B.M. Mahajan, Learned Counsel for the petitioner, submits that
Para 1890.
submits that the. So you admit there was some altercation?
Yes, my lord. Yes.
Submits that there was an altercation between the petitioner and the informant side, and in the ensuing scuffle, the informant suffered injury.
My lord.
Stop. He further submits that the ingredients of Section 326 IPC are not attracted.
Absolutely.
Stop. On the other hand, Mr. D. Das, Learned APP Assam, strongly opposes the prayer of the bail. Stop. I have heard the submissions made at the bar and have perused the materials available on record. Stop. It appears from the injury report.
Injury report.
It appears from the injury report available in the case diary that the injury sustained by the informant, yes, is of
multiple small lacerated
wounds
in left temporal and left parietal.
In the head. In the head. Stop.
3 stitches.
Stop. How many days?
1 day, 7 days.
Considering the totality of the circumstances, this court is inclined to grant bail to the petitioner. Stop. Accordingly, it is provided that the accused petitioner named above shall be released on bail in connection with the above noted case with a bail bond of rupees 30,000?
My lord.
30,000 only, with one surety of the like amount to the satisfaction of the learned
Kamrup Metro, my lord.
CJM Kamrup Metro, Guwahati, subject to the following conditions. 1. The accused petitioner shall cooperate with the investigation. Number 2. Indirectly, inducement. Number 3. Refrain. Return the case diary, the bail application stands disposed.
Highly obliged, my lord. Obliged, my lord.
Item 1.
Since your lordship is seized with a big matter, or perhaps there are two hearing matters of
Yes.
criminal, perhaps those are not likely to be taken up there.
Are the counsels present in court? In item 52 and 53? In 53, when do you want to have it? In 53, as prayed for, list this matter again for hearing in the after 2 weeks on a date to be fixed by the registry.
Well, Lordship, the matter ought to be for admission. However, wrongly it has been
Okay.
listed on here.
Then say that, why are you not saying in item 53, you say that Mr.
A. Iqbal.
Mr. A. N. Iqbal submits that the matter has been wrongly listed in the hearing column. Stop. Registry is directed to list the matter. Registry is directed to verify the same and list the matter for admission after 2 weeks on a date to be fixed by the registry. Next. 52, anyone there? You are there in 52? As in 52, you say none appears for the petitioner when the matter is called. Stop. Mr. Dida's additional APP present. Stop. List this matter after 1 week on a date to be fixed by the registry.
So our list is over. I may be permitted to leave.
Yes, Mr. Das.
Obliged.
There is 154. Are you there, Mr. Das?
There's one order. This is orders, Nikki.
No, hearing another one is there, 54.
My lord, the matter may be adjourned.
As prayed for, list this matter after 2 weeks on a date to be fixed by the registry.
Yes, sir.
Obliged.
Obliged.
Now you call the partner.
Chat. You have a reply. Oh, well, this became this big.
You've been filing affidavits on all dates, Mr. Mehta.
No, Lord, I think that blame should be shared by both of us. But both of us mean both sides. But,
Yes, anyway.
Anyway, my lord, I am not going to take your lordship to every page. Most of them may not be relevant. It's just to complete the record we must have
Just
placed
1
it.
second, Mr. Mehta. Ora, এইখন গুচাই দিয়কচোন নহ'লে দিগদাৰ হয় ফাইলটো ডাঙৰটো Yes.
Lord, I would address your lordships and assist the court on merits as well. But first of all, I wish to place page 317, which is a chart, which, my lord, according to my respectful submission,
Page, Mr. Mehta.
317.
317
Yes.
of the writ petition
Yes, of my reply, my lords.
of your
There is a
reply.
continuing pagination.
Of your reply filed on?
Lord, pagination would be continuing, my lords.
All right. 317.
Yes.
Continuous pagination.
Yes. Annexure E.
Annexure E.
Yes.
This is deprecated by the Supreme Court, my lord. That's my respectful submission. That same party, Lord, approaching various high courts. Please see Karnataka. The petitioner is column number 4, Southwestern Railway Catering Contractors Association.
Mr. Mehta, I believe on the very first day you had drawn the attention of the court to this annexure. In
Correct,
fact,
Lord.
we have marked it. Karnataka High Court MS Rathore Service P1, Guwahati High Court Rathore Service, and then respondent number 3 who had filed before the Jharkhand. Right?
Correct, my lords.
Yes. This is
So, my
taken
lord-
note of.
Yes. So this is, my lord, an abuse of the process. And only on this ground the petition deserves dismissal. More particularly,
Forum shopping, are you saying?
my lord, I generally avoid that word being used. It's not in good taste, my lord. My lord, trying the luck before more than one forums. The forum shopping means, my lord, it's like saying housewife, that there is wife somewhere else also.
Yes.
I was just, my lord, on the lighter side saying that the word housewife would mean there is a wife somewhere else also. So, forum shopping means you can go and shop somewhere. It's not a good word, my lord, to be used. But, my lord, taking a chance in more than one high courts. Well, this would be more relevant because out of the 3 high courts, my lord, the 2 high court, by reason speaking judgment, in which, my lord, this Rathore service was either a party or member of the association, have rejected the contentions raised, my lord. That is my first submission. Now, my lord, I come on the merits of the case. My lord, please have a look at, my lord, page
For the
141.
Karnataka High Court, the petitioner one was a member of that association, correct? The association was before the Karnataka High Court,
Yes, my lord.
correct?
He was a member of the association.
He is the
Correct.
member of the association. All right.
Association. And in Guwahati, my lord, he himself is the petitioner.
Yes.
And
And before Jharkhand High Court?
he is member of the association.
Is the association there before the Jharkhand High Court? Yes.
Yes, my lord. And that was a petitioner before your lordships also. They
Petitioner
deleted it,
number
but my lord, then
Petitioner number 3.
yes, they deleted it, but the effect of it filing a petition simultaneously cannot be wiped out in my submission by
Very well.
deleting it when being pointed out.
Very well.
Now, your lordships, my lord, before I take your lordships through the merits of the case, my lord, I would take your lordships to 3 stages in which, my lord, this system of catering, my lord, passed through. My lord, earlier the system was that we used to engage contractors. Lord, your lordships are aware, my lord, this is on-board catering service. On-board catering service, my lord, necessarily stipulates that you can't cook the food on board for various reasons, safety reasons. You can't use gas cylinders on board, etc., etc. So you have to prepare the food somewhere, bring it at the concerned train, and cater it, my lord, that is, serve it to the passengers. But we have a corporation, my lord, IRCTC, my lord, which used to initially, my lord, in the policy of 2017, would prepare the food. The petitioners, like contractors, my lord, who were small-time contractors, would receive the food and only serve it on the flights, on the train, on-board service. Thereafter, my lord, it was impossible for the IRCTC in the entire country to have their own kitchens and everything. So, my lord, the second stage came where the railways permitted the contractors to procure food from wherever they can and serve it in the on-board. Lord, for example, Lord, a train starts from, say, Guwahati, coming to Delhi. Lord, I'm not aware of which are the stations, my lord, which come in between. But Lord, there would be some station where there would be a time for breakfast, time for lunch, time for dinner. So wherever the train is stopping, or wherever the nearest place where the breakfast or the lunch or the dinner is to be served, they can procure it from a caterer, local caterer, or a local restaurant, or any other arrangement which they have made on their own. Lord, I hope I am clear. Now, my lord, there used to be several complaints of lack of hygiene, lack of proper quality of food, some insects.
At that time, there was no accountability as from where this food is being collected, correct?
Correct. And
that is probably the reason why there were so many complaints.
Yes, my lord, end-to-end accountability. In case of this very petitioner, my lord, some insects were found. There were complaints regarding, my lord, several complaints, but I am right now, my lord, not going into that factual aspect. It used to happen with every contractor, my lord, like the present contractor, petitioner also. My lord, therefore, my lord, the government of India, through the ministry, constituted a committee to go into this question, because we don't want to compromise on the quality and hygiene of the food which is being served on board, my lord. If your lordships, my lord, can come to page 141.
Page
141 of my counter, my lord, we appointed a committee.
It's affidavit filed by respondent number 4.
I am obliged to my learned.
Yes, 141.
Lord, the committee's Lord, finding, Lord, recommendations I am reading.
This is AO of R4. Yes.
Para
Paragraph
9, your lordships have para 9.
Yes.
That the committee undertook a comprehensive exercise including studying the best practices of the hospitality industry, engaged in the catering business and including engaging with various stakeholders such as caterers. Basis this, it's issued the committee's report dated so-and-so where it made several recommendations. The review of eligibility criteria with more emphasis on technical parameters so that only capable and experienced professionals within bracket minimum qualification of staff provided in the catering field are engaged in mobile catering of railways. Licenses should be mandated with setting up standardized, organized, state-of-the-art kitchens. Now, please mark this, not something would turn on this. With modern, mechanized and ISO certified with minimum approved specifications, and meals would be picked up only from such designated kitchens. When your lordship will come to next page 142, each identified kitchen should be equipped with a CCTV monitoring as per enclosed schedule 2, QR code stickers, insulated food vans, etc. My lord, please mark QR code stickers. I'll explain, my lord, what is that. Then next, end-to-end accountability of one licensee, whereby a single service provider or licensee was vested with responsibility and accountability of both production of meals in designated kitchens and service on boards. Both things he will do. Development of base kitchen and logistic infrastructure to be made mandatory before commencement of the contract so that bidders are committed and inclined to make investment in required infrastructure and their stakes are high in case of poor service. More the stakes, my lord, more investment, I will not take the risk of, my lord, compromising on the quality or hygiene. Due to substantial investment involved in setting up such kitchens and for achieving economies of scale, licenses were to be incentivized by awarding licenses for train clusters where trains may be mapped with service locations and base kitchens for preparing route-wise clusters or trains. I'll explain not what is this. Then financial eligibility to be fixed in accordance with sound financial, infrastructural and manpower capabilities to successfully manage the services to passengers in such clusters. Licenses would also be responsible for statutory compliances such as FSSAI, tax laws, various labor laws, etc. Now, my lord, now the new scheme which is under challenge is based on this recommendation. Now, my lord, what is this scheme? My lord, earlier,
yes,
they used to, my lord, small contractors used to procure the food from anywhere. Now, the new scheme is that if you are starting from Guwahati coming to Delhi and say there are A, B, C, D, E places where there would be a time for lunch, dinner or breakfast, correct? At the nearest place, suppose the train, my lord, is serving, say, lunch at 1 o'clock. Then nearby place, when it reaches 1 o'clock, the contractor who will be selected should have his own base kitchen, not procuring from anywhere. I'll show from the scheme which is impugned. We have provided for the manpower requirements and their qualifications and their health, hygiene, etc., cleanliness, etc.
The contractor has to have his own base kitchen.
Base kitchen, so that there is end-to-end accountability. The contractor would prepare the food and he will serve the food. Now, what is this QR code?
Outsource.
He will not outsource. Lord, what is this QR code? Lord, this is something very interesting for us as citizens also.
Yes, I think you had mentioned this on the last occasion that now sitting in the platform or in the train, if one scans the QR code, then one can see the kitchen and how the food
How this, which kitchen prepared this food, what are the health, hygiene and cleanliness conditions, and how everything is being done. So there is end-to-end accountability. But the main part of the scheme is that you must have the financial strength and infrastructural capacity to have your base kitchens established as per our specification.
Financial strength and
infrastructural capabilities. Because you will have to buy machines, etc., because this would be a bulk production. Number two, we also said that earlier the contracts used to be given route-wise. That Delhi, Bangalore, Delhi, Jaipur, Delhi, Ahmedabad, etc. Now it would be a cluster-wise contract. Cluster-wise contract means in one area, we will identify by way of a mapping that one contractor can have more than one route.
Yes.
5 trains, 10 trains, etc. And the purpose is made very clear that accordingly you will have to proportionately make more investment in establishing base kitchens, in establishing, in enrolling staff, etc., etc. And therefore, more the investment, less are the chances of the person taking any chance for hygiene, safe, cleanliness, etc., etc., because he has invested the money. Now, please see, my lord, the scheme, my lord, which is at page 48 of the writ petition, my lords.
Page number
48.
Yes.
Look, this is the scheme dated 14/11/2023. Your lordships have that, Manoj?
Yes.
Please see the objective. From the experience gained during the past few years after implementation of Catering Policy 2017, it has been necessitated that state-of-the-art base kitchen infrastructure, adequate logistic and service infrastructure, deployment of qualified and skilled manpower to handle the food production and services have to be put in place, not only at originating but also at en route stations. You can't have base kitchen in, say, Assam, in Guwahati, and serve that food throughout Delhi. Whenever there is lunch, dinner, breakfast, the freshness of the food, that is the logic. Food production and services have to be put in place not only at originating but also at en route stations to ensure service of good quality and hygienic food to passengers on trains. Hence, it is imperative that an experienced professional agency is vested with full accountability of production of meals and services on board under IRCTC's direct supervision and monitoring of entire operations. 3.1.1. Catering services on trains over Indian Railways shall be managed by IRCTC under the framework of this policy and related instructions issued by Railway Board from time to time. Please come to 3.2.1. What is not relevant for either of our purpose on this side, I am avoiding. All trains shall be mapped with service locations and accordingly base kitchen shall be designated for pickup and supply of meals depending upon service requirements. Route-wise cluster of trains and base kitchens shall accordingly be formed in consultation with zonal railways before invitation of bid. To consider adequate volume and economies of scale, award of contract shall be done for a cluster of trains and the base kitchens mapped with the cluster instead of an individual train. So
what does the last part indicate, that the base kitchens mapped with the cluster instead of an individual train?
Yes. Earlier, as I have said, the contract used to be given per individual train wise. That the train starting from Guwahati to Delhi, there would be one contractor. Now, on that route, maybe I'm not geographically aware, another train starting from Guwahati to, say, Calcutta also would be a part of the cluster. third train going from
Guwahati to Patna.
Patna. That would also be a part of the cluster. And what would happen is that in that cluster, whatever, if you have got 5 trains, now there is no individual train. If you have got the award of contract for 5 trains, in 5 trains,
you can have one base kitchen.
Not one. That is where, my lord, that is the more important part. My lord, from say, I'll just, my lord, give an example of Assam, Guwahati to say Bombay, to Delhi.
Delhi.
It starts at, my lord, for example, 9 o'clock. I'm not aware, but this is a hypothetical example. Then in Guwahati, you will have a base kitchen. You will prepare the fresh food and serve the dinner. It reaches at place A, where there is a time for breakfast. At that place or nearby place, you will have a base kitchen where fresh breakfast will be prepared.
That is clear. But,
so at every place there would be a base kitchen, not at one place.
The idea is to serve fresh.
Fresh.
With the proximity of the time with which the train is scheduled to either pass through that area.
Yes.
Correct? That is
yes,
the idea.
Yes, my lord. Sometimes, my lord, it may be half an hour.
Passing through night and it is dinner time, around dinner time, then the base kitchen will be there.
Would be there.
That particular train.
I am obliged, my lord. Yes. Then, my lord, kindly come to 3.3.
No, but one thing still is not clear because you mentioned that one person might have 2-3 cluster of trains, right? Suppose he has it for one cluster and for the other. So can he have one base kitchen for all the contracts, or the base kitchen will be for one?
Yes, my lord. My lord, suppose in a route of say Guwahati to Delhi and Guwahati to Bihar, there is one common route. He can have one base kitchen. He need not have 2. But the idea is, my lord, more than one train, so that more than one base kitchens are to be installed, and more investment would ensure efficiency because he can't take it lightly. Then
if turnover has increased because substantial investment will be required now.
Yes. Now that's the idea, my lord. Then 3.3 system of allotment of operationalization, allotment and operationalization of contract. Tender shall be awarded for a cluster consisting of locations required for commissioning of base kitchens and trains identified in the cluster for service through 2-packet tender systems, e-tender. The selected service provider shall be responsible for commissioning and operation of base kitchens at required locations along with services of meals in all trains of cluster which shall be pre-notified with the bid. Now, my lord, contract agreement as per letter of award shall have 2 parts. My lord, your lordships may perhaps not be relevant, my lord, for but still, my lord, I just to give my lord a flavor, I may read.
Next, I think 3.3.4.
Correct, my lord. So 3.3.4, it shall be ensured that at least 2 distinct service providers are available in a particular route. In case of more than 50% of trains are terminated due to deficiency in services, the entire contract shall be treated as terminated to ensure accountability. That you have to be good and hygienic service provider for all trains. Then any request for exit by one...
In one route, there will be 2 distinct service providers.
Yes, because my lord, service providers are also qualifications are prescribed. They also will have to have infrastructure like, my lord, vans. Sometimes, my lord, the van with an air conditioner require air-conditioned van to bring the bulk of food, etc. My lord, with a view to see that it reaches in time. If there is only one, there might be a delay, my lord. That's the idea.
Right.
Then 3.3.6. Any request for exit by the vendor for any individual train or trains will not be permitted. Once you apply and you are awarded the contract, you have to complete it. License fee shall be quoted individually for each train in the cluster, but successful bidders shall be determined on the basis of total license fee quoted, etc. Now, my lord, model of operation and setting up of base kitchens. My lord, that is also very strictly provided to ensure, again, my lord, hygiene and my lord, health issues. it shall be ensured that meals of the trains are picked up only from the designated base kitchens under direct supervision of IRCTC. So you will not buy it from any local caterer or any local restaurant. You will have to have your own base kitchen. Then locations and specification for setting up of base kitchens shall be pre-notified in the tender document. Location of base, so we will decide that in this route, at these places you will have base kitchens, because that is the stage at which this particular route, this train would pass at the time of lunch or at the time of dinner or at the time of breakfast. Shall be decided keeping in view the transit time and delivery to the station so that there is no impact on the food quality. Lord, what is this? I'll just point out. Lord, suppose, say Patna, the train is partly passing through Patna. Patna, the train would reach at say 1:30, which is the time at which the lunch is to be served. But the food is, there is some time required for transporting of the food. So it need not be at Patna. The base kitchen can be 20 kilometers away, 30 kilometers away, so that you can have sufficient time that fresh food is served when the train serves, on your service provider serves the food on the street, serves the lunch on the food. And to meet the quality and hygiene in production as per laid down standards, the service provider shall be responsible for setting up base kitchens at all designated locations as per route and requirement of trains. Before commencement of the contract, the service provider shall bear the entire investment and make their own arrangements in land, building spaces having easy road access. Setup and commissioning of base kitchen at designated locations originating and en route station shall be mandatory within 3 months after acceptance of letter of award of the contract. In case of extreme exigency or unavoidable circumstances, an extension of time only up to 1 month for setting up of the base kitchen and ISO certification can be considered. Thereafter, the contract shall be discharged from forfeiture with forfeiture of security deposit and advance or so and so. Now, your Lordship may kindly see the 3.4.11. 3.4.10 and 11. 10, my lord, at page 51. 3.4.10.
10.
At page 51. The base kitchen setup outside the railway premises, not in restricted residential area, should be uniform in design with a minimum of 1500 to 2000 square feet. The kitchen should be well equipped with bulk production of minimum 1000 meals at a time. That's the minimum, depending upon, my lord, which cluster you are getting the contract. With adequate storage, packing facilities, restroom facilities, and pot wash areas. This is for cleanliness. It shall be ensured that each designated base kitchen is equipped with CCTV monitoring as per enclosed Schedule 1, QR code stickers, insulated food vans for transport to the station. Standard minimum equipment and specification of base kitchens are enclosed as Schedule 1. Deployment of catering staff shall be ensured by IRCTC as per the norms defined in Schedule 3. That some persons would be graduates in the hotel management, catering services, etc. Some qualifications are prescribed. Compliance of onboard service protocol shall be ensured as per Schedule 4. Deficiency, complaints and corresponding penalties have been defined in Schedule 5. It shall be ensured that the condition precedent to commencement of contract is fulfilled as per enclosed Schedule 7. IRCTC shall prepare the schedule of inspection and monitoring mechanism for monitoring of onboard services and base kitchens by the officers and staff, approval of which shall not be below the rank of Director, Catering Services, IRCTC. This is important. This is under in question. Annual turn, with a view to ensure that you are capable of doing all this. More than one base kitchens, more than one vehicles, more than one equipments which can serve 1,000, which can prepare 1,000, at least 1,000 meals per day, having so much of the manpower, etc. Annual turnover from food and beverage business Because I am a businessman, I might be dealing in plastics also. My majority turnover might be from plastic industry. No. Annual turnover from food and beverage business. Food and beverage business means production, sale and service of cooked food, which is to be verified through GSTR and duly certified by an approved chartered accountant with UDIN number. During the consideration of 3 financial years, there should not be nil turnover in any of the years under consideration. Then 25 crore for cluster A, average per year in the last 3 years. A is a bigger cluster. It consists of 10 trains, Rajdhani, etc. Then rupees 10 crore average per year in case, well, this is for cluster B. Mail express trains, it consists of 5 trains. Average per year in any of the 3 years. And for avoidance of doubt, an example is given below. I don't think that may be necessary because it's clear. Then annual net worth at the end of preceding financial year. Net
this is understood. Yes.
Correct, Manoj? Now, ownership of kitchen. Please come to 3.6.3. 6.3, page 52.
5.3. Ownership of kitchen. Yes.
Yeah. 3.5.3. I'm sorry. No, for cluster A, ownership of at least 2 operational ISO certified kitchen in any 2 different cities in India with a valid FSSSI license having the capacity to produce at least 2,500 meals per day each and proof of supply of at least 45,000 meals each, i.e. average 500 meals per day. Meals include lunch, dinner and breakfast in any of the 4 preceding quarters. Then for cluster B, similar, proportionately reduced. Now in this context, please see 3.5.5. Minimum average workforce on roll, including having degree, diploma, certificate in any of the catering or hospitality related course during the last completed financial year. For cluster A, 150 staff on roll during last 12 months with at least 10 staff having 3 years of degree, diploma in hotel management or hospitality and 15 staff having certificates in any catering, hospitality related course from any government recognized organization or institute. Similarly, proportionately less in cluster B because the number of trains are less. Now, in this context, please see 3.5.7 with a view to ensure that you have the potential. Otherwise, what can happen is, I am a small contractor. I don't have the capacity. Here, what is required is my financial strength, my infrastructural facility, and my experience. What I will do is, I will have a JV with some plastic manufacturer or some textile manufacturer. And our JV will have the qualification. But eventually, I will be doing the service. I say, you come together in this very format with a textile manufacturer or a plastic manufacturer, but come as a partnership. And I'll show what is the logic behind this. That is 3.5.7. Joint venture or consortium shall not be allowed. So otherwise I am ineligible. But 10 ineligible people can gather together and become a JV and come with no inter se responsibility, rights, liabilities, etc. Now your Lordships may kindly see page 55. Page 55, my lord. Prohibition of subletting. This is a part of the scheme. Prohibition of subletting. Subletting of any kind, your lordship gets, man. Subletting of any kind during the contract operation is prohibited. Subletting of any kind, if noticed, must lead to termination of contract and debarment of licensee from future catering contracts. Subletting is strictly prohibited. following measures must be incorporated in the tender to confirm that there is no subletting. Measures may include, but not limited to, the following: issue of travel authority clearly mentioning the name of the staff, etc. Now, what can happen is subletting can become JV, and my lord, the person becomes eligible. We don't wish to, my lord, make anyone ineligible. You come as a partnership firm, you form a company, come as a company. My lord, just above that, my lord, your lordships may see no conflict of interest among bidders.
Where? Yes. Roman 2.
Yes, Roman 2. My lordships are right. I am obliged. My lord, a bidder shall not have conflict of interest with other bidders. Such conflict of interest can lead to anti-competitive practices to the detriment of procuring entity's interest. The bidder found to have a conflict of interest shall be disqualified. A bidder may be considered to have conflict of interest with one or more parties in the bidding process if they have a controlling partner is common, or so even indirect way of creating financial qualification is also prohibited. That you can't do this also. You must have your own inbuilt financial strength, infrastructural facility, and wherewithal to do what the scheme envisages. Base kitchen at every place with specifications, with equipments, with service providing equipments like vans, etc., that you must have your own worth, not based upon somebody's worth, and the same people enter. Your lordship,
in that situation, there could be a compromise on the quality of the food.
Correct, my lord, and
that is what is the check which you want to.
Yes, because yes, I'm grateful to your lordship. I could not have put it, my lord, better. Lord, what we are not, my lord, trying to leave someone. Lord, when there are allegations.
Sorry, I didn't get you. Leave.
Lord, the allegation was that with a view to ensure that we can't participate, this kind of a condition is put. Lord, whenever your lordships have the experience on this side and that side, Lord, when such an allegation is made, it has to have pleadings. Pleading means that you only wanted to have Reliance. In India, Reliance only has this qualified criteria, and therefore you have put it so that we, A, B, C, D, E, are not qualified to participate. Here, my lord, the intention is not that small people or small contractors are somehow kept out of the race. The purpose of the qualification prescribed is that we need big players who can have the wherewithal, because ultimately this is a scheme for the benefit of the passengers. This is not, my lord, a kind of a social sector, my lord, or a social justice scheme for upliftment of small traders. For them, my lord, everything is open. For example, my lord, on the platform there are several contracts. You have canteens, you have several things, you can bid for that. There are several things you can bid. But what is prohibited, you cannot do through the JV. That you take somebody's financial strength, and you who have failed earlier will come as a JV partner. That's the purpose. And there are no mala fides alleged. It's nobody's case that Mr. X is being favored or Mr. Y is being favored. My learned friend, my lord, my colleague said that there would be nobody who will have these qualifications. My lord, for this 7 clusters, we have 15 tenders.
How many participants? 15.
15 bidders, my lord, who are qualified. They have, my lord, all these qualifications. They have the qualification of, my lord, 25 crore and 10 crore. They have the qualification of.
Insisting that all your bidders should be from that empanel list?
No.
So they can be anyone.
Anyone, my lord. Empanel list also, there is some confusion. My lord, what happened was.
We will come to that. You can address that on later on. You can carry on. Proceed.
Yes.
Yes.
So this is an open tender, my lord. Not anybody can participate. And my lord, even if he is not enlisted or in that list of approved, person. But we have at least 15 tenderers only for this cluster who pass the muster of financial strength, who pass the muster of past experience, and who have the wherewithal with what is stipulated in it. So that is the idea. Now, if your lordships can consider, my learned friends contention about that approved list. What has happened is, and I'll take your lordships to page.
Approved list means that empaneled list.
Empaneled list, empaneled.
With regard to that, the first query of this court is, on what basis did you prepare that list, number one? What was the object, and was there an advertisement or something, or how were they selected? How were they panelled?
Yes, now, first of all, I'll answer that question. But now that approved list has pale into insignificance.
You have given away.
Now we are not selecting from that approved list. But my learned friend had shown some document that we are now selecting from the approved list. But what was that? I must satisfy your lordship's conscience on that. But what happened was, till this scheme become operational, the new contractors under this scheme who are qualified are selected, and their base kitchen and other infrastructural facilities are operationalized. They become functional. We can't stop the services for that temporary duration. We want approved people to continue doing this. It is that contract, which my learned friend had shown. Please come to page 146 of my counter affidavit. 146, para 60.
Yes.
Para 16. That due to the impact of COVID-19 pandemic, Ministry of Railways had earlier directed IRCTC to cancel all the existing catering contracts. It should be all. However, while the contracts were later restored, because we were prohibited from serving food during COVID, your lordship would recall. Later restored, new tendering was mostly done by IRCTC in the form of limited tenders or of short-term catering contracts of 3 to 6 months tenure for individual trains. Also, some special trains are introduced for a limited time for a specific purpose. For this purpose, service providers were met. The technical and financial eligibility criteria were empaneled by IRCTC on a rolling basis to enable them to bid for such short-term contracts and, if successful, begin operations on a short notice period of even 24 to 48 hours. For this empanelment, expression of interest was issued by IRCTC on a monthly basis, specifying the nature of trains for which such contracts that would be awarded if the bid was successful. Empanelment is only for a temporary or stopgap arrangement. No vested right or entitlement can be drawn from such empanelment beyond what is provided in the expression of interest. So they would continue till these new people awarded under this scheme, new scheme, take over. And if any of this contract, empanel contractor also fulfills the criteria, financial and other experience criteria, they can also bid. My learned friend's apprehension that there would be nobody who will bid. We have 15 competitors for this cluster only. There would be a different position for other clusters. There also we are getting the tenders. There are people who are eligible. They have the capacity, financial, etc. I am not repeating. Now, my lords. Yes, my lord, there is one tender specifically which my learned friend, my lord, invited your lordship's attention to. My lord, kindly come to, my lord, my affidavit, page 631. My lord, it is affidavit. It is called response affidavit of 4th of March. So there is one pilot project. It's something completely different, distinct, and totally different from the present scheme.
this is response affidavit.
Response affidavit, my lord. The
600.
pagination, fortunately, my lord, is 631. It's continuing pagination.
631.
631, yes, my lord.
Yes.
There are 8, my lord. The petitioner has referred, I'm sorry.
Yes.
The petitioner has referred to a pilot project of Yatri Seva Anubandh to contend that joint venture consortiums were eligible to participate in the said tender.
This is your reply to that argument where
Yes.
subsequent tender they have shown that JV was allowed.
Yes, my lord. This is a pilot project for a different purpose. I'll show that, my lord. It is submitted that, as the name suggests, this commercial circular number 29 of 23 has been issued on a pilot or test basis. Besides, the nature of the contract is substantially different in this tender vis-a-vis the licenses with its objectives, eligibility, and contractual duties and responsibilities for caterers with which no parity can be drawn. In any event, the relevant facts in relation to the same tender are being placed for consideration. That pilot project is for what? There you have to come as a JV, because housekeeping is also included, cleaning is also included, entertainment is also included, everything. There is a combo which government is considering, that then you cannot have the facility of cleaning. You can have one cleaning company as a JV, etc. Please see, November 23, a pilot project was conceived and initiated by Railway called Yatri Seva Anubandh, where multiple different kind of services were envisioned to be provided by the licensee as an experiment. Some services in the pilot via tender include housekeeping services, that is application-based service with minimum manpower and qualification prescribed, food and beverages services, application-based service.
Understood. All right.
Yes.
So this is how you are distinguishing.
And this is only for one zone on a pilot project base, that is called Southern.
As far as the present case is concerned, here it is only relating to the catering of
Preparation and serving.
That is only.
That is only. Plus, my lord, this was on a pilot trial basis only in southern region.
So you want to say that since there's multiple services are involved, one JB which might have expertise in catering and another member which has expertise in housekeeping, they both together can come form a JB.
Concierge services, my lord, you can book a taxi, for example. My lord, if I want to deboard in Bombay, my lord, there would be a concierge services on train where I can book a taxi, my lord, from Churchgate to Borivali. On-board infotainment, that is also, my lord, one of the services. Then vending travel essentials and miscellaneous products. So you get soap, you get wafers, etc., etc. My lord. So that also, my lord, these are all a plus the person who will come and put your blanket and your bedroll, etc., etc. But this is a combination, and this is on a trial basis only in the southern zone. Lord, only 6 trains, my lord, will be covered by this.
All right.
And my lord, this scheme is a national policy and will continue permanently till, my lord, some experience is gained and something is found and something better comes up. My lord, this would be because you are asking people to invest at every station, at every place with base kitchens, services of staff, etc., machinery required, etc., etc. So this can't be a temporary thing or a pilot project. So my lord, both are completely different. There, my lord, we have permitted JV because of the very nature of the contract, and second, it is a temporary pilot project.
Followed.
Now, my lord, 5 or 6 judgment which I will not read. I will read only 1 or 2 because I know, my lord, your lordships are fully aware of the propositions which lay down, my lord. I have filed judgment compilation, my lords. I'm sorry, my lord. One more fact, my lord.
Yes.
My lord, in Jharkhand High Court, this contention was specifically raised.
Which one?
Jharkhand High Court.
No, which one? Which contention?
Yeah, JV.
All right.
JV. My lord, I may assist your lordships what Jharkhand High Court has said, my lord.
Where is the decision of the Jharkhand High Court?
752 is the writ
part of the
petition
proceedings
file.
now?
It is a part of. We have placed the writ petition also on record.
Page number?
My lord, 752 is the writ petition and the judgment is 717. Writ petition is placed just to
Sorry, Mr. Mehta, page number for the judgment?
717.
717.
Yes.
It's all right, Mr. Gogoi, I've got it. Yes.
My lord, the relevant part, my lord, all contentions are noted, considered, which I have, my lord,
Just 1 minute, please.
Yes.
Mr. Gogoi, this is dated.
917.
Dated.
This file and that reply response affidavit.
27/2/24.
It's 4th of March, my lord.
Yes.
My lord, please come to page 739, the relevant part. My lord, the rest, whatever I have argued, my lord, is argued and is reproduced. There are 10. I am only, my lord, showing the finding on JV part. Otherwise, all contentions are accepted.
Yes.
Para 10. It has been asserted by Mr. Sanjay, my lord, the petitioner's counsel, learned senior counsel appearing for the petitioners, that
The
clause.
Association's counsel.
Yes. That clause 3.5 of the Commercial Circular 25 of 2023 demonstrate the eligibility criteria as the turnover required for Cluster A and Cluster B are beyond the financial capabilities of the petitioners and have been purposely incorporated to eliminate the petitioners from the tender process and is tailor-made to favor the contractors of Vande Bharat as also large hospitality industries. It is now the contractors who have to prepare the food in kitchen set up as per ISO, which is against the 2017 catering policy. Well, this policy which I read is amendment of 2017 policy. Catering policy and the provisions are designed to eliminate such contractors as like that of the petitioners. Mr. Sanjay has harped upon clause 3.5.7 of Commercial Circular 24 of 23 while reasoning that there is no rationale for ousting joint ventures and permission to bid through joint ventures would have allowed the petitioners some breathing space. Breathing space means to have association with some outsiders. And my lord, come. The respondents have allowed participants of joint venture or consortium in other projects, and he, in this context, has referred to Commercial Circular number 29 of 2023. My lord, that pilot project, my lord, which I pointed out to your lordships, was a bone of contention there also, wherein at clause 8, joint ventures or consortium has been allowed to participate, which has further been enumerated in the standard bid document. It has been submitted that in the addendum, there is no ceiling limit which would encourage monopoly practices. Mr. Sanjay Learned Senior Counsel has submitted that perceptible change in the policy of 2017 through the addendum and its discriminatory contents are palpable on the face of it. The unbundling of 2010 policy by 2017 policy seems to have been negated by virtue of the addendum, and the same has been specifically brought into existence to favor a chosen few and create a monopoly while ousting the petitioners from ever participating.
Finding, Mr. Mehta?
Yes.
Where is the finding?
Yes. My submissions are para 11 to 13.
I think the same submissions you must have made there.
Yes.
Let us see the finding.
Page para 21 at page 750.
Para
21 at 750. Page number 750.
Yes.
What can be culled out, your lordship gets one?
Yes.
What can be culled out from the aforequoted judgments is that limited scope the writ court has of judicial review of the tender process or the decision-making process. The rationale behind issuance of Commercial Circular 24 of 23 has been suitably explained in the objectives as well as in the counter affidavit and impugn circular is based on sound reasoning, and such administrative action does not espouse any arbitrariness. The policy is aimed at benefiting a large section of passengers by providing them with good quality hygienic food. In these modern times, upgrading the facilities in the trains and making endeavor to provide good quality food prepared at standard kitchens supervised by IRCTC are laudable exercise initiated by the respondent, which will ultimately benefit the travelers in the train. The act of respondent in issuing Commercial Circular 24 of 23 does not suffer from any arbitrariness or unreasonableness and was not designed to exclude the petitioners and bestow favor on someone. The exclusion of joint venture or consortium in the addendum is also as per policy decision of the respondents, and though the learned senior counsel for the petitioner has referred to Commercial Circular 29, that is my lord pilot project, but the same relates to a pilot project of Yatri Seva Anubandh, and it encompasses several facilities which has to be ensured by the service provider. The pilot project operating in a separate domain cannot be taken to be a benchmark to question the action of respondents and term it as arbitrary. The question which were formulated in case of Michigan Rubber and so, and which has been quoted above is answered in the negative. This court, in exercise of powers, etc., my lord, the court declined, my lord, to interfere.
Yes.
An empanelment argument, my lord, was rejected by Karnataka High Court, my lord. May I show, my lord? 638, the judgment starts, my lord. This very 638, this very volume, my lord. Judgment starts
68.
Where, my lord, this argument that we are all empaneled and eligible is noted at para 3.
Mr. Gogoi, you have a separate copy of that Jharkhand judgment. You just give one. It will be easier for me. Karnataka, I already have it. I have marked. Yes.
Lord, para 3 at page 644, Lord, this submission is recorded.
644, Mr. Mehta.
That's the finding, my lord. That's the submission recorded.
Regarding the empanelment?
Yes, my lord.
Yes.
Correct, my lord. I'm not, my lord, reading that. No.
Very well. Paragraph 3. This is the submission, correct?
Yes, my lord. Finding page 662.
Page
Para
662.
662, para 12. This is, my lord, Karnataka High Court. The first in point of time.
Yes, yes.
Karnataka judgment first, then, my lord, Jharkhand, and now, my lord, we are assisting your lordship.
Yes.
But para 13, para 20 is also, my lord, my submissions are recorded. 13 is the finding. Your lordship gets, my lord, at the foot of page 662.
Yes, at the bottom, yes.
Petitioner want this court to enter into an arena of food preparation and monitoring as to where the base kitchen should be, who should distribute food, and who should be accountable for such distribution. If all these submissions are accepted, it would amount to this court monitoring the preparation of food and distribution of food in the trains, which is...
All right, I have seen this.
Yes.
Karnataka, I have already read the judgment. All right.
Only, my lord, take the judgment compilation.
Yes.
I'll only one or two judgments. Otherwise, my lord, I have given the proposition on the as a title. Lord, I am not.
You must be relying on Michigan?
Yes, my lord. Michigan, my lord, is already relied upon, my lord, by Karnataka. But please see, my lord, the title, the index only.
Yes.
We play in the joints to the executive in decision making of economic policy. I'm not. This is, my lord, the judgment. Para 79 is the relevant para.
Very well. Free play in the joints.
Yes. Judicial principles for exercise of discretion in tender matters under Article 226.
Yes.
Lord, para 26. Now,
Yes.
this is important, Lord. Read court cannot modify a tender condition. Lord, there, my Lord, kindly come to page 87, para 9 and 10.
$87?
At page 92, it starts at 87. Lord, the 10 would be more relevant, my Lord. 9 is Tata Cellular principle quoted, my Lord.
Yes.
But just above para 10, see the last line, last 4 lines, the court would not, Your Lordship, I'm sorry, page 93,
Yes.
Just above para 10, last 4 lines.
Yes,
The
the court should not
would
interfere.
not interfere with the terms of the tender notice unless it was shown to be either arbitrary or discriminatory or actuated by malice. It was further held that while exercising the power of judicial review of the terms of the tender notice, the court cannot order change in them. The principle is therefore well settled that the terms of the invitation of to tender are not open to judicial scrutiny, and the courts cannot withhold down the terms of the tender as they are in the realm of contract unless they are wholly arbitrary, discriminatory, or actuated by malice. This being the position of law settled by a catena of decisions of this court, it is rather surprising that learned single judge passed an interim direction on the very first day of admission hearing, my lord, etc., etc. This is, my lord, then, my lord,
Yes.
on the my lord, index.
Yes.
Tender conditions to be read as a whole. So please come to judgment starts at page 96, para 10, my lord.
What is the relevance of tender conditions to be read as a whole? Because we are not interpreting this.
No, but why the prohibition of JV? Your lordships may consider the entire scheme
Yeah,
and find out
basically,
the object.
you see, initially this court was putting the query as what is the object that you are trying to achieve, correct? By way of your affidavits, you've demonstrated that.
Correct.
And, in fact,
That is the reason. That's all.
Clauses also.
But if your lordship reads the clauses, the entire scheme, the purpose, intent, or object of
There is some justification. Now, whether this court is not going to weigh that justification. There are reasons.
correct.
Correct.
Lord, and my lord, another is allegation of malafides are more easy to be made than made out. Your lordships are aware it's a well settled principle. You have to name the person who is to be benefited, why, who is actuated by malice, which officer, etc. My lord, these are, and last judgment is simultaneous filing of writ petitions in various high courts is an abuse of.
Which is that?
Lord, that is at page 170, All India State Bank Officers Federation.
All right.
Para
11 and 12.
11 and 12. There, my lord, the various associations, my lord, sub-associations filed various petitions challenging some circular. The court says they should have come together and approach one court. This is a misuse of the process because you are taking a chance before every court.
Very well.
So these are my respectful submissions.
Very well. Mr.
Lord,
Chaudhary?
yes, my lord. We're grateful. It was indeed privilege assisting your option.
Yes, Mr. Chaudhary?
Yes, my lord.
Where are your pleadings for arbitrariness and malafide in your writ petition?
Yes, my lord.
That Aru file আছে নেকি? Chaudhary, you had only submitted copy of the case laws, right? Earlier, Mr. Chaudhary.
There's an affidavit also.
You had submitted the copy of the case laws earlier, right?
Yes.
Only the case laws, nothing else. No? There was no written submission. Yes, Mr. Chaudhary.
My lords, the pleadings, my lords, on arbitrariness and all your lordships will find, my lord.
Sorry?
The pleadings on arbitrariness which your lordships wanted to see, my lord.
Yes.
First, my lord, straight away have page 7, paragraph 3. My lord, it's in fact
Page number?
7, paragraph 3.
Yes.
The petitioners further submit that to make matters worse, the impugned commercial circular expressly prohibits not permit joint ventures consortiums to bid for the clusters. Then the clause is quoted. The stringent and restrictive clauses introduced by the impugned circular are completely discriminatory against the individual M-panel caterers, as the said caterers cannot on their own bid for the cluster of trains and are also prevented from bidding.
All right.
for the same by forming a joint venture consortium. The clauses of the impugned circular are tailor-made for particular vendors with a view to eliminate the small individual caterers and are violative of the fundamental rights.
Yes.
Now, similar pleadings are there, my lords. I don't want to bother your lordships. In fact, on the grounds also, if your lordships come.
Yes.
Also, my lords, page 20, my lords, my submission on consultation, my lords, that stakeholders were not consulted. Page 20, my lords.
Yes.
That the stakeholders were not consulted, my lords. Earlier, there were consultations which happened, my lords, before any significant change in policy.
Para 15.
Yes, my lords. In breach of the said practice of holding consultations with stakeholders and taking their views before formulating the policy or taking significant policy decisions, the respondent number 2 has unilaterally arbitrarily issued the impugned circular, including significant and wide-ranging changes in the catering policy, which are unreasonable, arbitrary, discriminatory. Your lordships will just mark here, my lord, page 159 of the counter affidavit.
Page?
159. Alongside paragraph 15, my lords, your lordships will just mark paragraph page 159.
Yes.
Where the
G, I think you had already referred to this.
Where they said, my lords, that yes, in earlier consultation used to happen. There was no consultation in this policy. Since this is not a new policy, it is an addendum to the 2017 policy. Right, my lords? Now, my lords, on this addendum,
little further, if you can read just on my behalf.
Yes.
Little further.
Yes. My lords, I'm reading 159, my lords.
Yes.
The second sentence onward, it is submitted that it is true that Railway had consulted with the stakeholders before introduction of any major catering policies. It is humbly submitted that the circular dated 14/11/2023 is only an addendum to the catering policy 2017, and hence the consultation of the stakeholders before induction of addendum to catering policy is not required, as the addendum dated 14/11/2023 introduced by the Indian Railways to meet the shortfalls in the catering policy 2017, and hence the non-consultation of the stakeholders may not.
Mr. Mehta wants you to read this portion. In the instant case, the
respondent had consulted with the stakeholders before the introduction of the commercial policy circular 24 or 2023. In any event, as detailed above.
Because this being an addendum, probably this is what.
Yes, madam. Now, this argument of addendum
into all this consultation and all that.
This argument of addendum, my lords, flows from page 48. Just have page 48, my lords, of the policy.
Yes.
At the top, my lords, addendum to the catering policy. Right, my lords? Now, let's straight away come to page 54. This addendum is a misnomer. They have completely superseded the 2017 policy. This is a new policy. This policy, a lot has, my lords, 54. This policy supersedes. Yes. And related instructions.
It supersedes paragraph 3.
Yes, my lords. And related instructions, except the provision for sharing of license fee revenue between the Indian Railways and IRCTC. Except the provision for sharing of revenue, my lords. This has superseded, my lord.
Mr. Chaudhary, you are trying to. You are now arguing that this addendum has superseded the entire 2017 policy.
The paragraph 3, my lord, and paragraph 3 is the crux.
On this paragraph.
Yes, my lord. Because paragraph 3 of the 2017 policy, your lordships will find at page 101 onwards. That's the hub of the matter, my lords, where, my lord, the entire catering system was in place.
Just 1 second. Can you read page 54? Can you read that again? The applicability of this policy.
This policy supersedes para 3 of the catering policy 2017 and related instructions except the provisions for sharing of license fee revenue between Indian Railways and IRCTC as referred to in paragraph 3.1.2 of this policy.
Right. Can we now go to para 3 of catering policy 17?
Yes, my lord. Page 101.
Page 101.
Yes, my lord.
Yes. Management of catering service, that relates to catering service.
Yes, my lord. The management of catering services in mobile units.
Page 54 says it supersedes only this.
Yes, my lord. And this paragraph 3, your lordships will see, my lord, this is a detailed paragraph. Now, 102, your lordships will see method and operation of the mobile catering service.
Yes.
Then 3.8 is setting up operation of base kitchens. So all these, my lord, is superseded.
Because it's relating to that issue.
Yes, my lord. Then also have 106 my lord, general instructions.
Yes, 106.
Yes, my lord.
General instructions.
Yes, my lord. So, my lord, my submission is this, my lord. The catering policy, my lord, the nub of the catering policy is the mechanism for monitoring of the catering services. So that itself has been changed. There's been significant change in this policy. So for them to say that since it is an addendum, we did not consult, my lord, in my respectful submission, is not proper. Now, my lord, yes, my lord. Now, my lord,
Yes.
now, my lords, I had pointed out at the beginning, my lords, that there is a list of M-panel caterers published by IRCTC. That is periodically published, my lords. That list is valid. That list earlier had 62, my lords, till December. And in the fresh list, which was published on 3rd January 2024, my lords, after the impugned policy, has a list of 72 caterers who are, my lords, eligible to participate in the on-board catering services.
Yes.
Now, my lords, there is no answer from the Indian Railways as to how many of these caterers, because you have the list, you know the pool. How many of these caterers are eligible to participate under this new policy? It's a significant downside, my lord. From 72 eligible catering contractors, my lord. Now,
But
in
if
this,
I understood Mr. Mehta correctly, they are saying they are not in this list anymore. It's an open tender. Anyone can.
Yes. Well, open tender, but these bids which have taken place, nobody from outside has come. All these bidders who have participated are from the list of M-panel
15 bidders that have participated?
Yes.
They were qualified, so they participated.
So, my lord, it's not that somebody from outside has come. The list is known, the pool is known. So, my lord, when the pool is known and the standards of empanelment, my lords, are very rigorous, my lord, just have that, my lord, your lordship had asked that query also to me, that what are the standards of empanelment of a caterer? That, my lord, your lordship will find, my lord, in the supplementary affidavit filed by, my lord, the Indian Railways, IRCTC, at page 333, my lord.
Page number?
333. Extremely rigorous standards, my lord. We are tested.
333.
Yes, my lord. Your lordship has that. And expression of interest is invited, my lord, by a public tender.
Yes.
Your lordship will see, my lord, expression of interest 2024. My lord. This happened, my lord, pursuant to the impugned circular. So to say that this list has been done away with is not correct, my lord. This list continues. The process.
I'm sorry for interruption. Not impugned circular. It is not under impugned circular.
No, sir. I'm saying it came after the impugned circular. This
expression of based on it.
Yes. Yes. So, my lord, 333, your lordship will see, my lord.
Mr. Chaudhary, this EOI is dated. Where do I find the date?
This date, my lord, is
signature 11/2/2024. No,
14. No, my lord. That's, I think, the signature 14 February.
Lord, since last many years, every month this is issued. It gets revised, additions are made, etc. And this is only for one train as a stopgap arrangement. No, not for the present purpose, my lord, that cluster, base kitchen, etc. They have to fulfill the conditions mentioned there.
You have?
Fulfill the conditions mentioned in that scheme.
Now, my lords, this expression of interest, the lordships will see, my lords. Just permit me to read it from the top. Expression of interest 2024 for empanelment for provision of on-board catering services in various types of train in Indian Railways.
Yes.
And just the, my lords, serial number 4, validity of empanelment is till 31/12/2024.
Yes.
So they have continued with this list, my lords. Now please see, my lords, at page 336.
Page 336.
So this list is drawn up, my lords. The list of 72 now.
Yes.
Invitation for EOI, your lordship has that?
Yes.
The EOI
336, right?
Yes, my lord. The EOI 2.0, my lord, your lordship has that?
No, at page number 336, Mr. Chaudhary,
Yes, my lord.
it says 3.0 schedule of process.
Just before that, my lord, invitation for EOI 2.0.
Yes, 2.0.
Yes. The EOI sets out all the requirements that must be satisfied by applicants for getting MPanel as a service provider in order to participate in the process of limited tenders for provision of onboard catering services in various categories of trains, and it is an invitation to the applicants to submit their profile document for empanelment as service provider. Now, my lord, 339.
Mr. Chaudhary, just 1 second. Mr. Mehta, the 15 participants are from the empanel list.
No, I'm not sure, but they must be qualified.
Can you please find out the...
I'll just not find out, but I believe they must be, yes, they are from the empanel list, but they are qualified as per the qualifying criteria.
Understood, but what I further wanted to know, because since you have an empanel list, which
Yes.
which consists of, I think, about 72 members. Now, whether these 15 tenderers who has participated, submitted their bid, are from that list.
Subject to verification, yes, my lord.
All right.
They
all
are.
right.
But I can say, my lord, they are qualified as per financial criteria as well as per
That is a different
experience.
thing. That is, of course, a different thing. First and foremost is, you see, if this there are 15 people from that list which has participated, then perhaps we will not.
There's no mala fide, my lord, that's
go
all.
into that. Correct. That is
It's
why
not
I'm
an
asking.
intention to eliminate some. That's all.
Because if, in fact, on the last occasion also this question was put, because this court is of the opinion that if you are having a list, specifically you have selected tenderers and you've put them in a list, that is obviously you've done because you've checked them and you've prepared it, correct? There must have been some check and all.
Correct.
So now and that is also because you don't want anyone to come. You want people from that list to come, correct?
That
This
list
must be the
also
idea.
to come if they qualify.
All right.
From that list also they can come if they qualify.
So as far as the present tenders are concerned, that is not restricted to only for members of this list. In addition, anyone can also come.
Yes, others can also come, they can also come.
What is the use of having the list?
No, that's for temporary period, not for 6 months, for example, we have to give.
No, but you see, you have given the validity till December 24, the empanel list.
They can be selected for any 1 month, any 2 months, any 3 months for one train. And they are not under any obligation.
Have you verified this in any of your pleadings? Because there are 2-3 affidavits that you have filed.
Yes, but I'll just show. In my counter, my lord, I'll just point out to your lordship. This is only, my lord, what we have said is stopgap or temper. We have used with some word.
You can just point out the paragraph
Yes, kindly see.
after Mr. Chaudhary finishes.
Only
Yes,
page 146, para 60. Page 146, para 16.
Paragraph?
16.
16. All right.
May I just read so that this issue is clear. Also, some special trains are introduced for a limited time for a specific purpose. For this purpose, service providers were met the technical who met the technical and financial eligibility were empaneled by IRCTC on a rolling basis to enable them to bid for such.
This you have already shown. Yes. All right.
That limited tender part also indicated, lordship, in PT6. That limited tender part also indicated in PT.
Okay.
PT6.
Now, my lord, alongside this, when the lordships have this document, my lord, 341 minutes.
341?
Yes, my lord.
Yes.
Is the period of empanelment will be up to 31/12/2024.
Yes. Yes.
So, my lord, my respectful submission is this, my lord. Insofar as, my lords, the empanel list is concerned, my lord, that list continues. You have a list, the pool is known. Now, my lord, they have not stated how many from this pool, my lord, are qualified. So my respectful submission is, my lord, by making the conditions stringent, because you knew the financial capability, you knew the technical qualifications of all these tenderers, because they participated in an EOI, they disclosed their criteria, they disclosed their strength, they disclosed their financial strength, based on which you have now prepared a list of M-panel contractors. Because once you have prepared a list of M-panel contractors, they know which are the contractors who are eligible to participate. My respectful submission is, as I pointed out earlier, I don't want to repeat that clause 3.5.1, which has increased the annual turnover limit, read with clause 3.5.7, which prohibits, joint ventures and consortium, has dropped down, the field to a minuscule numbers, It denies me a level playing field, because we otherwise, as an M-panel list of caterers, are with the same level, The field has now been made uneven. It cannot be level playing field, cannot be claimed by someone who is unequal. But we are all equally placed, in the list. And that level playing field has been disturbed, in my respectful submission, which has, substantially brought down the number of participants in the tender process. Now, one important aspect is this, the learned solicitor submitted, that we are open to partnership. But joint ventures lack accountability. Joint ventures we are not permitting. My respectful submission is this, that the decided cases which I have already placed, from New Horizons to Gammon India to Fakir Chand and the Guwahati High Court judgment in Prism Logistics case, have stated that joint ventures are in the nature of partnership. They are governed by the same rules of partnership. That passage your lordships will find in New Horizons also, which states, I'll just read out, I'll not bother your lordships with that. The passage from New Horizons,
Yes.
The expression joint venture is more frequently used in the United States. It connotes a legal entity in the nature of a partnership, engaged in the joint undertaking of a particular transaction for mutual profit, or an association of persons or companies jointly undertaking some commercial enterprise wherein all contribute to the assets and share the risk. It is in the nature of a partnership. My respectful submission is, there is no basis, much less any reasonable basis, to oust or keep, the joint ventures or consortium from a commercial contract. These are known commercial entities, it is a known business entity, So by excluding joint ventures, you are substantially bringing down the field. Secondly, joint venture does not mean that there will be no accountability. Accountability will remain even in the pilot project which I pointed out, which is for a period of 5 plus 1 year, 7 years. There they are allowing joint ventures. Obviously, the nature of investment will be such. The nature of the investment required is such, that if you allow joint ventures, it will enhance the field. To say, that joint venture will bring down the quality, it will not meet the quality standard, in my respectful submission, is not correct. Secondly, in so far as the quality standards are concerned, we are saying we'll meet the quality standards. All M-panel catering contractors, are capable, of delivering this service. All the M-panel caterers, are capable of delivering the service, the best quality food, the hygienic quality of food, the base kitchens, whatever is required will be done. Only
Mr. Chaudhary, earlier when they were empaneled, at that time, these requirements were not there, base kitchens and all, correct? Those days, those empaneled people, the participants, they can purchase, procure it from, or do outsources and then distribute.
There were two options, Base kitchen was brought in by the 2017 policy, So
Okay.
many of the caterers have their own.
No, IRCTC.
A few of them had.
Now what has happened is, my lord, now in the entire cluster, my lord, in the entire route, you will have to have.
No, I think that time it is the kitchen which is the IRTC, and one has to go purchase it from there and bring it and then distribute. I think that is what, if I recollect.
But 2017 policy, my lord, even had the caterers, my lords, to have a base kitchen. Base kitchens were there. But now, my lords, in the entire route, my lords, they have to have base kitchens in every particular thing. That's the requirement now. Now, my lords, if the base kitchens are required, I'm not telling your lordships that don't have base kitchens. I'm not telling your lordships, but that's not even the purview of my writ, my lord. That's not even what I'm arguing, addressing your lordship. I am saying whatever requirements are there, my lord, whatever hygiene requirements are there, whatever food quality standards have to be met, will have to be met, my lord. There can't be any compromise on that.
So they have now justified through their affidavit. They have shown us the reasons. Plus, even in that circular, in the addendum also there are clauses which indicate their object.
Yes, my lord. The object is laudable, my lord.
They are now while exercising powers under 226, can this court enter into that arena? Because
No, I'm not asking your lordship to.
exercises have been done by the railways,
Yes.
and they
Yes, my lord.
have sought out a mechanism to ensure that good quality fresh food is served to the customers. That is the
Yes, my
end
lord.
result that they want to achieve.
Yes, my lord.
And they don't want to do any compromise there.
Yes, my lord.
Correct.
On that, my lord, we don't join issues, my lord. We are at par. We are saying yes, good quality, hygienic food as per standards specified will have to be met, my
Now
lord.
it is their perception
Yes, my
that a JV will not be able to give that result
Yes, my
because
lord.
because in a JV there could be other members who are not having experience of catering, maybe
Yes, my
doing
lord.
some other business. Now they might be associated and they might together bid, and then ultimately people having no experience in the field might come in. This is one of their. This is what has been argued, right, Mr. Chaudhary?
Yes,
So,
yes.
yes.
Now, my lord, what I submitted, my lord, that the nature of the JV is such, my lord, it is in the nature of a partnership. I may have a financial partner with me, my lord, but ultimately the JV has to deliver according to the standards, according to the specifications required.
And according to you, since it's in the nature of a partnership, so it will be fully accountable. So
It
if
is
you are
fully accountable.
permitting a
Yes, my
partnership,
lord.
why not a JV? This is your argument.
Yes.
Note.
And I'm not even
All right.
suggesting for a moment, my lord, that this should be brought down the technical standards insofar as, my lord, hygiene and all is concerned. I'm not even suggesting. We are, my lord, with the railways, my lord, it has to be the best quality food, the hygienic food. Now, my lord, what I'm submitting is, my lord, that by increasing, my lord, putting this condition as a pre-qualification criteria, it is restricting as a pre-qualification criteria, my lord. As a pre-qualification criteria, my lord, it is restricting, my lord, the competition. It is restricting the field, which, my lord, is against CVC circular. CVC circular says, my lord, the pre-qualification criteria, I've already placed that circular, my lord, should not be so stringent, my lord, as to restrict the field of participants.
All right.
Now, my lord, by restricting the field, my lord, obviously it is impacting the competition. And more the bidders, my lord, the more will be the competition.
This you've already argued.
Yes, my lord.
Yes.
Now, my lord, the last few points, my lord. That ceiling limit I have also pointed out, my lord, under the 2010 policy, my lord, there was a 10% ceiling which was to be there against the contractor, my lord. That ceiling limit has been done away with by this particular policy.
Ceiling limit of?
The number of contracts which a particular tenderer can hold.
Yes.
So this will, my lords, result in a monopoly.
Yes.
That ceiling limit, your lordships, I had already pointed out at page 92,
Yes.
and my lord, at page 53.3.4, that you will have two distinct. First is 92-93 of the 2010 policy, my lords.
Yes.
Which expressly prescribe the ceiling limit.
Yes. Mr. Chaudhary, do not repeat the arguments. You can
I'm
specifically,
not.
if you want to reply, give a reply. You've
Yes,
already made these arguments.
My lord, just to conclude, my lord, that the bidders who are there today, my lord, in the fray has substantially come down from that M-panel list of 72. This, my lord, has restricted competition, my lord. My respectful submission.
When conditions are made stringent, there is bound to be some
Yes,
reduction, but
but
that alone cannot be a ground for interfering.
no, that's right, my lord. But the point is, my lord,
In
your
fact,
lord,
there are also decisions to the effect, even if you make a if you make a legal point, merely because you are making a legal point, also
yes,
this
yes,
court may not
Cochin, yes,
interfere, because
only
at
on
the
the
end
making
the
of a legal
public
point.
interest is also involved, because
Yes, sir.
it appears that their object is to ensure that the customers, the quality that the customer will get is not compromised. This is the basic, correct?
I'm not joining issues on that. I am saying that quality we also will give. But the point is, my lord, with these conditions, my lord, which are impugned before your lordship, my lord, the
Yes.
field has been substantially brought down.
Yes, this is what we've
The
been arguing from day
yeah,
one, that the restrictions have been curtailed.
yes, my lord.
Because of the addendum, the
Yes, my lord.
participants have been restricted, correct?
Yes, my lord. Yes, sir. And lastly, my lords, the judgments, my lords, of Jharkhand High Court and Karnataka High Court, my lords, I only submit, my lords, these are only of persuasive value, my lords. Your lordship knows, my lords, that they are not binding. Your lordships are open to take a different view. And this writ petition, my lords, was the first in point of time which was moved before this court.
All right.
I'm grateful, my lords, for
Grateful.
your listening to us.
Obliged to us.
So we'll close it then.
Yes.
All right.
Obliged to your lordship.
Hearing concluded, reserved for judgment.
Grateful.
Obliged.
CAB.